Good morning, everyone. I'll wait a few more moments before we get started.
Good morning.
All right, I'll start by looking first to Ms. Taylor Scott. Are you ready for us to go on
Yes,
the record?
I am.
Thank
Whenever
you
you're
very
ready.
much. And I will start with introductions. Good morning. It is November 4th, 2024. I'm Nicole Kinsey, presiding hearing officer for the Administrative Hearings Office of the State Water Resources Control Board. This is the hearing on the pending petition for assignment of state filed application 25517 and accompanying water right application 25517X01 and the pending request for release from priority of state filed applications 25513, 25514, 25517, the unassigned portion, 22235, 23780, and 23781 in favor of water right application 25517X01 of Sites Project Authority. The hearing today is being conducted by Zoom and is also being broadcast live on the AHO YouTube channel. Both the audio and video of the hearing are being recorded and will post files of this recording in the FTP folder for this proceeding. The YouTube recording will also be available on the AHO YouTube webpage. If you're experiencing technical difficulties trying to communicate with us today or accessing the Zoom platform, please send us an email to the site's email inbox or to the AHO email inbox. AHO staff are monitoring those and can let me know. We will take breaks today as usual. We will hold our normal hard stop at 5 p.m. And we again have Ms. Mullen assisting us today with the exhibits. So if you are a witness or an attorney, please feel free to address Ms. Mullen directly to advance slides or pull up a particular exhibit. I will carry over appearances as usual, although it's been a little while since, well, not that long since we've seen each other. To pick up this morning, I thought we should clarify where we are, what we have left to do. I did send out an amended hearing notice last week that included the 7th as a possible day. I just wanted to reserve it just in case. So right now we have on the books today, tomorrow afternoon, starting at 1 p.m., and then if necessary, the 7th. I understand that for the SDWA parties that Mr. Rato is not able to join us today and has some medical matters to deal with, which I understand. So we can talk about it, or as you have more information, and I'll turn to you, Mr. Rees, in a moment, more information about whether the 7th, we should plan on the 7th, or Mr. Rato. I originally intended to hold that as a backup day, but this may be the reason to have it as a backup day. So Mr. Rees, do you have any updates on what you expect?
Good morning. Yes, I'm certain that he tells me that I can be certain that he will be available on the 7th. If the 6th was much less likely, but if it came to that and there was no other reason to hold a hearing on the 7th, then I would, when we're at a break this morning, I would try to make that happen if possible. But I know that he's available on the 7th. If there's I don't want you to have to do a hearing just for him, but
No, I understand. We'll play it by ear to see if that's necessary. And by the 6th, I assume you mean the 5th.
I'm sorry, I mean the 5th.
We're skipping the
Yes,
6th.
yes.
Good. Thank you for that. And then I will turn to the NGO collective, if I may, and tribal interests. I believe we have Chairman Mitchum as possible, and then Dr. Rosenfield. Is that correct understanding where we are? I'll look to you, Mr. Busher, because you're off mute, but that may be unfair.
No, that's fine. Dr. Rosenfield is available today, tomorrow afternoon, and Thursday if necessary. Obviously, we'd like to get it done sooner than later, but
Great.
Whenever he needs to get started, we can. And I don't have an update on Chairman Mitchell.
Okay. And then I believe our one remaining witness, in addition to those, would be Mr. Ornbaun. And Mr. Ornbaun, I see you're here joining us today, so thank you. Good morning.
Thank you.
My proposal then would be, based on this information, is that we start with Mr. Ornbaun, and then I see we have Mr. King here as well. I think we can start with Mr. Ornbaun and then deal with any evidentiary objections and then turn to Dr. Rosenfield, unless there are other proposals. Dr. Rosenfield, did you have, or Rose, I don't know who, Ms. Rosenfeld, is that correct? And who are you representing?
I represent Calusa, Your
Okay.
Honor. And I wanted to update on Chairman Mitchum's availability. He's not available this week, and I'm not sure about his availability thereafter. So I certainly understand that it is possible he won't be able to present his testimony during the period of time available for the case in chief.
Thank you.
That's all the information that I have. But Margaret
Understood.
for Rosenfeld, Foreman Shapiro and Rosenfeld for Calusa.
Thank you, and welcome, and thank you for joining us, and thank you for that update. Are there any other comments on the proposed order of go, if you will, this morning, starting with Mr. Ornbaun and then dealing with evidentiary objections, because we have Mr. King with us, and then moving to Dr. Rosenfield? Mr. Hitchings.
Yes, good morning. Thank you. With regard to Chairman Mitchum, it appears that we're going to conclude likely the case in chief portion this week, maybe even by tomorrow. And if it remains indeterminate as to his availability, I think a decision needs to be made whether the direct case in chief testimony is withdrawn, and perhaps that can be put together again as rebuttal testimony. But I don't think we should have an open-ended date for that to occur, given that there's really no update. So I would propose that that be the approach, that if he's not available by the time we conclude, then we should consider withdrawal and repackaging as rebuttal as appropriate.
Thank you, Mr. Hitchings. That would be, I'll comment on this and then look to see if there's any addition, but that would have been is, excuse me, the coffee's kicking in, is my intent. Of course, if Chairman Mitchum isn't here to be available for cross-examination, then his testimony would not be admissible. And we are scheduled to conclude this week, and if he's not available, then that looks to be where we are. As you mentioned, we can revisit this issue possibly on rebuttal in accordance with the rules that govern rebuttal testimony and related, in the sense that it has to be in response. It would need to be in response directly to the authority's case in chief. But is there any, I don't know if any representatives have a response to that approach to handle Chairman Mitchum's testimony?
Well, this is Don Mooney. I don't think that there would be a great prejudice to the authority if we just had his case in chief testimony added at the time of rebuttal. At a later time. I don't think we need to set a whole new hearing date for that when he may be available. But again, it's very short testimony. And they have the testimony. So I think if during the rebuttal period, he could hopefully be able to testify. But at that time, that would be considered his case in chief testimony. Because there can be a distinction between rebuttal testimony and case in chief testimony in terms of what's allowable.
Yes. Mr. King, did you want to jump in on that?
Yes, just from a point of equity and respect for the indigenous peoples of Colusa County and Quetzalcoatl, I support. I don't understand all the complexities of litigation, but I support the position taken by Mr. Mooney as a party to this proceeding.
Thank you, Mr. King. Mr. Hitchings, did you want to respond?
Yeah, in no way is this a showing of disrespect to the circumstances on behalf of the authority, but the proceedings should be applicable to all participants that filed their notice of intent to appear in accordance with the hearing notice. And so with regard to if Chairman Mitchum isn't available for his case in chief testimony for cross-examination and to attest to it as part of case in chief, then under the rules of the proceeding, that shouldn't be included as part of the case in chief, and we should move on to rebuttal, and there be opportunities to participate in rebuttal, cross-examination, closing briefs, just like any other participant in this proceeding.
Thank you, Mr. Hitchings. I think the way to deal with this, it is an evidentiary dispute at this point. I realize this is coming up. We weren't sure about Chairman Mitchum's status and whether he was going to be available for cross-examination. So I understand, Mr. Hitchings, that this may be, I'm not sure to the extent it's already addressed in your evidentiary objections, but this may be an additional basis for objections. But I think we should deal with this in writing in the package of evidentiary objections, and then of course the other representatives and other parties would have a chance to respond to those objections. So let's handle this in that way. I'm not going to rule on this issue now.
Okay, thank you.
Thank you. Are there any other procedural issues we should address before we turn to Mr. Ornbaun? Mr. Busher.
Yeah, I wanted to raise a issue and question with respect to the incidental take permit that was issued since we were last together. We have had a chance to begin review of the materials that sites uploaded to the FTP. We have not at all completed that. It is a lot of complex analysis and conditions. We've also reached out to Sites Authority and to the Department of Fish and Wildlife to get a copy of the spreadsheet modeling tool that they used in their process. And hopefully we'll have that soon from one of those sources. But ultimately, the conditions in the ITP are different, and I think potentially materially so than the conditions in, than those that were proposed by sites and that we've been considering for the last 3 months. And there's changes to the Wilkins Slough diversion limit. There is a maximum annual diversion limit. There's what the department calls a flow-dependent diversion limit. And then a host of other criteria in the conditions that are contained in AHO 300 regarding minimization of take and impacts on endangered species. And as a result, we've heard a bunch of testimony about a project that is not the project as approved or conditioned by the Department of Fish and Wildlife. And that has impacts well beyond just the impacts on endangered fish in that ecosystem, right? That impacts whether or not there is water available and the water availability analysis that sites proposed. That impacts the cost benefit analysis of the project if the water becomes more expensive, and whether it remains beneficial from a public interest standpoint. And then it also impacts the fish and the riparian corridor analysis related to other endangered species that we've all heard testimony about. And I think ultimately what that means is that from the case in chief, right, sites has presented evidence to meet its burden that is evidence that's not about the project that is going to exist. And as we move forward in rebuttal and the remainder of this hearing, we think it's important that sites present its evidence about the ITP before we have to respond to that ITP at the same time. And so I don't know whether that means we extend case in chief or whether we stagger the deadlines for rebuttal or whether we postpone the deadlines for the rebuttal testimony. But there's a whole bunch of questions as a result of that ITP and a whole bunch of analysis that sites has just not performed through no fault of their own, right? They analyzed the conditions they proposed, but the conditions that they got back were different. And moving forward with rebuttal evidence 5.5 weeks from now on the ITP from both sides at the same time, right? That's prejudicial to the protesting parties who don't have all of that underlying information and modeling and analysis available that sites has had available with the department for the last year while the application has been pending. And I'm not sure I have an elegant solution to that issue or those questions, but we think it's important that we pause and figure out how sites is going to meet its burden to show water availability and public interest and other things within this hearing based on that ITP before the protesting parties are forced to present their evidence about the ITP and its impacts.
Mr. Hitchings.
Yeah, I would say that this is exactly why we did not have the rebuttal scheduled until we did in this matter. And we intend to address those issues in rebuttal with regard to water availability, with regard to impacts on fish and wildlife, all of the hearing issues. We intend to do that. If anything, the terms and conditions that have been placed on the operations by CDFW under its ITP, they've just become more limiting than anything else. So to the extent that there would have been impacts alleged with regard to the operations of the project with the ITP, arguably the ITP has put terms and conditions in place that would lessen those impacts. So I think everyone will have an opportunity to review the rebuttal testimony and exhibits that are submitted on the date that's been set, and we'll have the opportunity to prepare cross on that when that starts in January. If after that there's a showing that there's a need for possibly some SIR rebuttal and a showing is made and good cause is shown to do that, I would suggest that would be the approach to take, not to at this point disturb the schedule that's been well thought out and put in place.
Thank you, Mr. Hitchings. Mr. Reese, do you have a comment on this issue, or did you have a different?
No, yes, please. It's on this issue.
Okay, great.
The South Delta parties, we share in the comments and concerns that Mr. Busher has made. The ITP is complex. We're just beginning to review it. There are references and statements in there with respect to south of Delta, increase in south of Delta exports that we don't fully understand. We haven't fully understood that through the case in chief until cross-examination. Even with that, it's difficult to understand. So the case in chief has been largely about trying to figure out what's going on versus really more effective cross, which I think would have occurred with a staggered schedule. So now we're talking about doing rebuttal testimony that's due here very soon, which isn't rebuttal testimony. What's the ITP rebutting? I mean, it's not rebuttal testimony. It's additional testimony that needs to be part of a case in chief because it pertains specifically to site's burden on these various elements. And if we're going to do it where it's both do it the same, if you're going to use it, call it, rebuttal testimony, I think at a minimum it needs to be delayed and it should be staggered so that we can have more efficiencies moving forward, trying to figure out so that our cross and trying to figure out really what's going on is much more effective moving forward.
Thank you. Mr. Mooney.
Yeah, that was my comment as well. I'm not sure how the ITP testimony about site's testimony about the ITP could be considered rebuttal. I mean, there is a distinction. They're not rebutting any testimony. They're putting forward new evidence, and it's really case in chief if they're going to present evidence on that, and it goes to how they're going to operate the project. That's their case in chief. They're not rebutting anything the NGOs said. Fish and Wildlife, they haven't provided testimony. They're not rebutting that testimony. They're addressing significant modifications to the project that, for right now, nobody fully understands what impact that will have on the project. And so we shouldn't be prejudiced, as Mr. Busher said. We shouldn't be prejudiced by having to address this in rebuttal or somehow address it in SIR rebuttal when this isn't rebuttal testimony. This is case in chief testimony.
Thank you, Mr. Mooney. Mr. King.
Yeah, so we haven't had a chance to look at this and how it may affect the takings along the Colusa Trough, historical Colusa Trough, Colusa Basin drain. So I'm just going to just assert my support of Mr. Mooney, Mr. Busher, and Mr. Reese in their position because we haven't had a chance to look at it. But I think the interests align as it relates to takings on the historical Colusa Trough and the Colusa Basin drain. Thank you.
Thank you, Mr. King. I'll reflect back on, Mr. Schutz, please go ahead.
Thank you. I have kind of a narrower concern with this, and it's not just having to do with the ITP itself and how that's handled, but also substantively, for me at least, the ITP changes what I would say in rebuttal. So it's not merely a question to me of how, as a distinct matter, we're going to deal with the ITP, but how the ITP affects what I plan to say substantively in rebuttal. And for me, a particular concern is the fact that I have used a tool presented by the Sites Authority to evaluate the diversions that would occur and what that would do to the hydrograph and so forth. And now we have a new tool that we don't have. And to me, that's a particular urgency. And the longer I don't have that tool with a deadline in front of me, the more complicated it is for me to try to figure out what exactly the diversion patterns, particularly at lower flows, would look like. So I just wanted to call that particularly to your attention, that it's more, in my opinion, than how we're going to address the ITP. It's also that substantively the ITP changes potential rebuttal testimony per se. Thank you.
Thank you, Mr. Schutz. Mr. Mooney.
Yeah, just kind of add on to a little bit what I said is that, I mean, technically, I mean, if we could use the ITP as rebuttal testimony with respect to that the project that they have analyzed is not going to be the project. But because the ITP rebuts, this is evidence rebutting, say, the flows at Wilkins Slough. But it's not, but again, sites using that testimony or that the ITP is not rebutting anything that's been presented by the protesting parties.
Thank you. Go ahead, Mr. Hitchings.
Yes, Mr. Mooney mentioned not just now, but before that, this is new evidence. Rebuttal testimony exhibits are going to be new evidence. This CDFW ITP, we issued it basically contemporaneous with when we received it. Mr. Busher asked me on Friday for the modeling tool. I wrote back to him promptly, told him I would be checking in with the client. It's Monday morning. Haven't heard yet, but I expect to hear in a timely manner. All of this will be provided. The ITP already has been provided well in advance of the rebuttal deadline. And so, and I disagree that this is not rebutting the cases in chief of the protestants in this matter, who have largely alleged unreasonable impacts on fish and wildlife and other related hearing issues. And if anything, again, this is more limiting than the project. Our application is for up to amounts of water, up to a maximum rate, all the elements that are part of a water right application. And so I stand by the suggestion that we should stick to the schedule. And if there's a showing and a need for SIR rebuttal after that, then that would be the appropriate procedural way to handle this.
Thank you, Mr. Hitchings. And Mr. Busher, please.
Yeah, just one last short point. I appreciate Mr. Hitchings' note that the conditions imposed are more restrictive on operations than what we've heard about previously. I will note that the analysis by CDFW is limited to endangered species and is a different standard than, and a different scope of protection than the obligations that the Water Board has in terms of protecting beneficial uses like fisheries. And so the fact that there are restrictions with respect to endangered species doesn't necessarily answer the questions about those other beneficial uses that are related, or those species that are not endangered. And so it's of a different and more limited scope. But Other than that, I agree with kind of what Don and Dean have added here.
Thank you. And I think, I mean, this is not our last day together this week, so I do want to continue to think about this issue and we can revisit it. But here's where what I'm thinking at this point. When we went forward with this schedule, it was my intent to go forward with case in chief without the ITP. It was my thinking at that time that the ITP would come in on rebuttal, and it would essentially be like a piece of case in chief evidence that was coming in on rebuttal, and we would deal with that accordingly, and that there would be sur rebuttal with respect to the ITP. I think what has possibly, I don't want to say changed my thinking, but what I'm hearing from the protestants is that the conditions in the ITP, because they are different to some extent than those proposed by Sites Project Authority, that the impacts of that information are somewhat pervasive in the rebuttal, the protestants' rebuttal case. I'm not sure that dissuades me from going forward with the schedule as is. It's to me more of an argument that there will be sur rebuttal with respect to issues related to the ITP, and with the understanding that the ITP and the conditions included therein may affect a broad scope of the hearing issues. So my inclination right now, and I would like to think about it, and we can have additional discussion on this, but my inclination would be to go forward with the rebuttal portion as is, but I would issue a written ruling and clarify the scope, my understanding of this, of a minimum of what the scope would be for sur rebuttal, so that the protestants can plan accordingly, and you can conduct, to the extent you are able to conduct analysis and bring it in on rebuttal, that would be appropriate. And to the extent you may have additional sur rebuttal that responds to cross-examination or testimony submitted by the project authority with respect to the ITP, that you would be able to address those later in a sur rebuttal portion of the case. But I'm not making any, we should all think about this. So, but I will look again to the room. Mr. Busher, you were up first.
Yeah, the one thing I raise, and I understand both sides of the thinking that you're expressing there, or both parts of it, I guess, not both sides. One thing that results in is 2 rebuttal phases for all of the protesting parties, which means we got to do a whole bunch of work to do rebuttal now, and then we got to do it all over again after Sites does its ITP presentation, right? And that's just burdensome and kind of inefficient for us, right? We got to go back to all these witnesses who have testified or other witnesses that we want to testify and say, we need you once. And so I think we could, let Sites present whatever, its rebuttal or the ITP portion on the current schedule, and then do a single rebuttal phase after that, so that we don't have to continue and do 3 phases of this hearing rather than 2. Because that is just, right, that's just a ton of extra work and burden on parties that are, as a general manner, right, under-resourced and overtaxed. And it makes participation in this process, and then all of the other processes that are going on unrelated to this one, but in the same watershed, much more difficult if we have to do 2 rebuttal phases instead of 1.
I can understand that. Thank you, Mr. Busher. Mr. Mooney.
My one comment on your thoughts is that we still don't have a time when we will be provided the modeling tools that have been requested, that were referenced in the ITP documents. We don't know if those will be made available to us this week, next week, or if we're going to have to file some type of a formal request with either the agencies to get that information. And until we have that information, it's my understanding that really impairs the ability to conduct the analysis. So as our rebuttal date creeps forward, the longer we don't have that information, the more prejudiced we become.
Thank you, Mr. Mooney. Mr. Reese.
I'm just going to share that. Yeah, we don't know, maybe once we know when, relative to what you were indicating your thinking was at this point, once we know how long it's going to take and how adequate it's going to be in terms of what we receive from the modeling, we might be more informed. And if you were going to go forward, kind of consistent with what you were thinking, I feel like it should at least be a staggered testimony or staggered schedule. The authority is, knowing what they're dealing with regard to the ITP and the modeling for a long time. We just received this and don't even have the modeling. So I don't want to beat the point up, but I think it's prejudicial if we're just going to go forward as planned, even with a sort of a bifurcated scope of rebuttal.
Thank you. Mr. Hitchings.
Yeah, we have no objection to setting a deadline for that. As I mentioned, we're promptly following up on that. Mr. Busher sent me the email on Friday. He asked for the diversion routing analysis tool. If there are additional modeling tools that protestants want beyond that, that's the one that's noted on Cites Exhibit 300 at page 19. I would suggest that the list of any additional modeling information that the protestants are seeking, that should be provided to us, so we're not guessing at what is important or what's needed. And I'm doing everything I can to respond as quickly as I can on the one request that we've received so far. I would expect that if there are additional modeling items that are requested and needed, we will get that out as quickly as we can. I don't think this week is a problem at all, and hopefully the beginning of this week.
Thank you, Mr. Hitchings. I think this makes sense to table this. We may have more information as soon as later today or tomorrow, it sounds like. So let's table this. I do want to think about this and what makes the most sense and is the most efficient for our time. Most efficient and also addresses the issues here. As I said, I knew this was there was be some added complexity by going forward with the case in chief without the ITP. So this is not unexpected, and we can think through how to deal with this. Are there other procedural issues we should address this morning other than what we've talked about already? With that, then I would like to turn to Mr. Ornbaun. And good morning, Mr. Ornbaun.
Good morning.
And I will start by administering the oath, and we'll go. Ms. Chester, did you have a comment?
And this may be the wrong order, but I was hoping to get clarification from Mr. Ornbaum about an email sent out this morning entitled November 4th that has a list of items. I was just hoping to understand if that was an outline for his opening statement or if it was a submission of testimony.
I think it's my closing statement. I'm not a lawyer, so I thought I'm just overviewing. This is my closing statement, I thought. I don't know.
I'm at a little bit of a disadvantage because I don't believe I've seen
Okay,
this email.
That is sufficient clarification. It sounds like it's not intended to be testimony, so I appreciate that clarification. Thank you.
Thank you. Thank you, Ms. Chester. And thank you, Mr. Ornbaun, for addressing that. I will go ahead and administer the oath, Mr. Ornbaun, and then I will ask you to affirm your submitted written testimony. And then if you would like to summarize your written testimony, you will be welcome to do that at that time. And then we will see if any of the parties have questions, well, particularly the authority, have questions for you. It looks like, Mr. King, you have a comment before we get started.
Yes, so I think Mr. Ornbaum, I don't know, since he hasn't been part of the proceedings and not a lawyer, whether or not he intended to make an opening statement, which would be just part of the administrative record, and then give his testimony. So maybe Mr. Ornbaum expected what he sent today to be an opening statement, since a closing statement won't be for some time, because that's my understanding. So I think, I don't know if Mr. Ornbaum has any thoughts on that, whether or not he intends to make an opening statement, which would not be part of the evidentiary record, and then go into his testimony. So I just want to bring that up since Mr. Ornbaum has been part of these proceedings for a while.
Thank you, Mr. King. You are right to correct me. I did not mention the opportunity for an opening statement. So let me backtrack here. Mr. Ornbaum, you are welcome to make an opening statement. This opening statement is not part of the evidentiary record. It's not testimony, but generally opening statements are used to summarize the issues that you think are important here and that the State Water Board should be considering in making the decision, and relate those comments to the evidence that has been submitted. And then if you have an opening statement, we can do that first, and then we can move to administering the oath and going forward with any evidentiary testimony that you plan to provide today. So, Mr. Ornbaun, do you have an opening statement that you would like to give?
My closing statement will be my opening statement. It's the same issues that I've talked about. So,
thank you.
All right.
And with that, I'm sorry, go ahead. Then with that, I will go ahead and administer the oath, and we will go forward with the evidentiary portion. If you would please raise your right hand. Mr. Ornbaun, do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And with that, Mr. Ornbaun, I'm going to look quickly. I think I clicked out of the right box. I'm going to ask you to confirm and affirm the exhibit that is your written testimony. Let me pull it up here. And I'm looking to my team. Do you have a, oh, here we go. I believe the document that you titled opening statement that you submitted to the AHO in July includes the portion that you intended to be your written testimony, and that would be, we have it titled as Ornbaun 11. And I believe you submitted it as a document entitled opening statement. Is that correct? Is that intended to be your written testimony?
I don't know. That's all the reasons I think that, we did address. That's all the things we should be addressing. I don't know. There's lots of backup in what I'm saying in the stuff that I submitted there a few months ago.
Thank you, Mr. Ornbaun. What I'm trying to confirm is whether which exhibit is your written testimony?
All of them. I mean, I don't know. I didn't write a written testimony for all those exhibits. All those exhibits are backing up my claim.
Let me ask this another way. Are any of the exhibits your words, your observations, your opinions that you wrote down and submitted this for the State Water Board to consider? I'm just trying to figure out which document that is.
Just the cover letter stacking up by other people's knowledge, other people's written down information.
Maybe I can turn, Ms. Mullen, can you pull up Ornbaun 11, please? Let's take this, that's probably the way to go. All right, and if we can scroll down to the next page. All right. Mr. Ornbaun, did you write this?
Yes.
The words on this page, and you intend this to be your testimony for consideration in this proceeding, and it should be considered as evidence in this proceeding. That's your intent.
Correct.
And can we scroll down, Ms. Mullen, just so we can get to the end of the testimony? Great. And based on that very quick scroll through, and we are in Ornbaun 11, Mr. Ornbaun, will you affirm for the record that this is appears to be a true and correct copy of your written testimony?
I affirm that this is a true and correct copy of my testimony.
Thank you. I appreciate that. That's all. I just wanted to make it clear on the record what this is and what we were looking at. With that, Mr. Ornbaun, would you like to summarize your written testimony? You're not required to. I mean, I've read it, but you are welcome to summarize or raise any particular points that you would like to raise, as long as it's within the scope of what you have written here.
I guess I've got about 8 points here just on one page that overviews that shorter. I mean, I'd be glad to read that.
There's no need to read it because I've read it.
Okay.
I just wanted to give you the opportunity if you would like, but you were very concise, so there's no need to be to redo that unless there's something you particularly wanted to highlight.
what I hadn't talked about that I would bring up, but it's not on there. So I just want
Right, you can't, yes, that may be appropriate if there's something that you are responding to based on the case in chief you've seen so far, that
Yeah.
may be appropriate for rebuttal. And that
Okay.
would be the time to do that.
Well, it won't take very long. I've just got this, what I submitted today would be case in chief's rebuttal then, I guess, you know. Is that what I'd be allowed to say?
What I'm saying is the rebuttal portion of this hearing will occur next year.
Okay.
It's going to start
Okay.
in
Then
January.
I guess whatever you'd like me to do, then I'm here.
If you have any questions, I mean, slow me down if you have any questions. We've been at this for quite some time, and I know you haven't been able to join us for all of it. So if we get going, then normally the next step. So I've read your testimony.
Mhm.
There's no need to summarize it here, but the next step as part of the consideration of that testimony is to allow the other parties, and in this case, likely be the authority, ask any questions of you with respect to that testimony or other questions on cross-examination. So that's where I would move to next.
That would be great. Sure.
All right. Thank you. Ms. Chester, do you have questions for Mr. Ornbaun?
Yes, just briefly, thank you.
Please. And Ms. Mullen, Ms. Chester, do you want
I do
Ornbaun
want this
11?
up. This
Okay.
is fine, thank you. Mr. Ornbaum, my name is Michelle Chester. I'm counsel on behalf of the Sites Project Authority, and I appreciate you joining today. I just have a couple of questions. Is it correct that you designated yourself as an expert witness in this proceeding?
Yes.
And did you submit a curriculum vitae with your testimony?
I don't know what that means.
Did you submit a resume with your exhibits?
No.
Thank you. What is your area of expertise?
I am a farmer. I use water. I move water. I understand how groundwater is recharged in our area, whether it be shallow groundwater recharge or deep groundwater recharge. For my lifetime as a farmer and my family's, we have the history of the water table for 100 years in that area, and the effects the Colusa Basin drain has done, helped us or harmed us. The effects of the West Side Canal have helped us or harmed us. The effects of Glen Colusa, the effects of 108. For my family's history and myself, I've seen and acknowledged and understand most of those effects.
Thank you. Can we please scroll down again to PDF page 2 of Ornbaun 11? Thank you, Ms. Mullen. Mr. Ornbaun, on the top of this page here, you state that site's combined place of use number is 15,942,960 acres based on table 2 in protest answers, correct?
Correct.
Ms. Mullen, can we please bring up Ornbaun 1, which is the protest answer? Thank you. Mr. Ornbaum, this is the protest answers document you're referring to in your testimony, is that correct?
Yes. Yes, it is.
Can we please scroll down to PDF page 5 at the bottom? Thank you. And just on to page 6, if it's possible. This is the portion of the protest answer that discusses table 2. And when we get onto page 6, this is the table 2 you're referring to in your testimony, correct?
Correct.
And for purposes of your testimony, you added up the numbers listed in the place of use acres for each storage partner to get the 15 million figure in your testimony. Is that correct?
That is correct.
And you state that Colusa County's listed acreage in the table is not fair. Is that correct?
That's correct.
And the place of use acreage doesn't tell you about the storage partner's capacity, does it?
Capacity, meaning
So
the acre.
for context, I apologize. I didn't mean to speak over you. I just it may help if we scroll up to table 1 on PDF page 3. I apologize. I believe it starts on page 4. Thank you. So I just wanted to understand that or acknowledge that the place of use acreage doesn't tell you about each storage partner's storage capacity, does it?
They have their estimated storage capacity for each partner.
And the place of use acreage doesn't tell you about the storage partner's level of investment in the site's project, does it?
It's their level of investment is acquired by their acre foot investment.
And is that information in table 1 or table 2? What's your understanding?
It's on table 1. So I believe that is the acre feet that each storage partner has at that time of this report.
Okay, thank you. Can you explain why it is that you think Colusa County should get a higher share of active storage in sites different from its level of investment?
Because Colusa County there's a large amount of acre feet derived in Colusa County from the watershed of Colusa County. I don't think the watershed of Colusa County should become personal property of the other investors and leave our county.
Can we please go back to Ornbaun 11, the PDF page 2 again? Thank you. So in the second paragraph on this page, you state that the MOUs between Glenn and Colusa counties and Sites Authority were agreed to before the understanding or consideration of groundwater recharge and controls were understood. Is that correct?
That is correct.
Are you referring to the MOU that's submitted as Ornbaun 8?
I'd have to look at it, but it's the MOU between Colusa County and Glenn counties to the Sites Authority.
Okay.
They were done years back. I don't remember what year. 10 years ago? I don't remember. We'd have to look. We'd have to look at the date.
Can we please pull up Ornbaun 8? Is this the MOU you're referring to in your testimony?
I believe so. And we look at the date, so it was 2010 or 2010. Yeah.
Okay.
And my statement was it was before we have new technologies now, and we have new restrictions from the state. That MOU would be obsolete today.
So is it your understanding that the MOU limits the amount of water available to Colusa County?
Yes.
What's the basis for that understanding?
Because if we go to the authorities' application of the water right that each partner would acquire, they can only acquire the water they can afford. The partners that would purchase the larger investment in sites would get more of the water, and our groundwater recharge and our well water will now be impeded, and then our well water we will be in a deficit. We have to replace surface water because we won't be able to use our well water. Will be restricted by the state of California. So these restrictions have come after this MOU.
Thank you, and I apologize for the interruption. I just wanted to confirm that your understanding of the MOU is not that it's intended to preserve the water necessary for development in Colusa County, correct?
Now, ask me one more time. I'm thinking too hard when you're talking.
Sure. Is it your understanding that the MOU is not intended to preserve a certain amount of water for the development in Colusa County?
It is my understanding.
Okay. Can we please go back to Ornbaun 11? And towards the middle of the page, please. Thank you. You say that if sites' water rights to the drain were approved, that would stand in front of our country and its citizens' rights. Do you recall that?
Yes.
And is your conclusion here that sites would have a higher priority to water excuse me, a higher priority water right to water users in the Colusa Basin drain?
Yes.
And what's the basis for that conclusion?
Well, today, natural rainfall falls, comes down the Colusa Basin drain, goes over the lands that I'm talking about, and our groundwater recharge is recharged at no charge to us. It helps our wells, and we are recharged at no cost to us. If Sites Authority impounds the water, then that water becomes private property of the authority or of the investors. And then that water then goes around our national recharge and is placed in the Colusa drain or the 2047 in Dunnigan. So the area of my concern, the natural recharge would not be allowed. It would go around and it would become private property and to be sold.
Can we please scroll to PDF page 3? Thank you. At the end of this page, you said that you submitted documents that show your understanding of recharge and the state's direction in equitable water recharge and rights, correct?
Correct.
The information you provided as exhibits doesn't include an analysis of how the site's project would affect groundwater recharge, does it?
No.
Okay. Thank you. Those are all the questions I have.
Thank you, Ms. Chester. And then Mr. Ornbaun, normally the way this works is if you had an attorney representing you, you would have the option to have the attorney ask you some what we call redirect questions. But essentially, you have an opportunity to respond to or expound upon any of your answers in response to Ms. Chester's questions. Is there anything you'd like to add based on what she asked you?
No, that's all. I agree with what she said and what I stated.
Thank you. Thank you, Mr. Ornbaun. I believe with that, that concludes the submission of your testimony, and I appreciate very much that you were able to join us here today, and thank you for your time, Mr. Ornbaun. I will, because you are here, I think what I would like to do is address your submission of evidence, and then also I'll turn to Mr. King. So you're now, we're switching hats. You're now stepping down from the witness box, so to speak, and now are representing yourself. But let me look to Ms. Chester. So well, let me ask you this, Mr. Ornbaun. Is it your intent to offer into the evidentiary record the exhibits that you have submitted and that the AHO identified on the FTP site as Ornbaun 1 through 16? Is your intent to offer those exhibits into the evidentiary record?
Yes.
And then I will turn to Ms. Chester, if that's appropriate. This was quick, but I didn't see until this morning any objections to Mr. Ornbaun's offer of exhibits. Did I miss that?
No, I believe we included language either reserving the opportunity or we, chose to wait until the deadline this Wednesday to submit objections. As of now, we would move to exclude Ornbaun exhibits 4, 6, 7, 9, 13 through 16 on the basis of lack of foundation. We would also move to exclude Ornbaun 11 on the basis that it is not appropriate expert witness testimony and has not complied with the requirements for the submission of expert testimony pursuant to the AHO's guidelines. We are willing to discuss those orally now and follow up in writing as needed or to the AHO's preference.
I think, well, and I'll look to you, Mr. Ornbaun. I know we're in lawyer land, and this is a little complex. I think it makes sense to address, since we're here today, I think it would make sense to address these orally. That would probably be most of, and I guess I'll look to you, Mr. Ornbaun. is it correct that your preference would be to address these objections orally today, or would you prefer to wait and have the opportunity to respond to the site's project authority in writing?
No, please ask me anything.
All right. So I think what makes sense, and Ms. Chester, feel free to chime in as well. What makes sense is just to step through these exhibits that to which the authority is objecting, and we can take a look at them right here on the fly.
Sure.
This will take a little time. I appreciate everyone's patience, but I think this is the way to manage this. It begins, I believe, with you identified some exhibits to which you objected based on lack of foundation. The first one was Ornbaun 4.
Yes,
and-
Ornbaun, I apologize. Ornbaun 4 and 16 are similar, so I would just suggest we address those together.
Great. Ms. Mullen, would you please bring up Ornbaun 4? And if possible, to rotate it so I can read the title, please. Thank you. I guess I'll turn first to you, Mr. Ornbaun. What are we looking at here in this exhibit? It looks like it's 7 pages long. What is this?
That's the flows that are measured on Highway 20, which is north of where I am. That the Bureau has a monitor that allows us to see the flows in the Colusa Basin drain. And that's me showing that these flows help recharge our groundwater. And the high flows specifically, when it's high flows, it covers more acreage, so it allows for more recharge. So the taking of Funk Slough and Stone Corral would lower those flows. There's different estimates I've received from the Sites Authority. I think before they said it was 11%. Now they think it's 8% of the flow would be.
Mr. Ornbaun, where did you obtain this exhibit?
I got it from off the internet from the Bureau of Reclamation.
All right, and I think I saw something. Ms. Mullen, will you scroll down a little bit? It looked like there was a web page, maybe in very faint writing at the bottom here.
Yeah.
I think one more click down if it will let you do it. I realize. There we go. I can't read the date on it.
January 31st, 24.
24. That is what it
30.
says. And does that accurately reflect when, based on your recollection, you
when I
downloaded or copied this data?
Yes.
Thank you. And then can we click down to the next page, please? And this looks like something different. So this exhibit is a compilation of information from different, acquired from different areas, from different places on the internet. Is that right?
Yeah. The bottom right where the color shows, that's from Sigma data. That one is showing that I can't quite see it to blow it up. Is it subsidence or is it groundwater? I had both in there. This is groundwater levels for those wells is what it's showing, the groundwater levels.
And this is also information that you obtain from on the internet somewhere?
From Sigma, yes. Yes.
So
and
from
specific wells, it's from a private individual that measures the depth of the groundwater.
But this information, these graphics, you obtain them from DWR's website?
I can't read groundwater levels. Yes, I believe so, because it says Sigma data. I can't read it all. But The
I'm
map,
not sure. We can have Ms. Mullen scroll in, but I'm not sure where you're reading here.
yeah. Yes, it's from Sigma.
And by Sigma, you mean DWR's webpage? I'm trying to understand where this came from.
That's the Groundwater Monitoring Authority, I believe. Those are I'm not good with all the initials. I don't remember all the names of all the initials.
What I'm trying to pin down, Mr. Ornbaun, for me to accept this exhibit, I need to know where it came from so that there's some indicia of reliability, that a reasonable person would rely on this. So that's what I'm trying to understand is where did this come from?
Sigma Data Viewer.
I see it says Sigma Data Viewer. Is that on the DWR webpage, or you don't recall?
No, I think that's a different webpage. That's a different web.
Ms. Kinsey, if I can help out here, the Sigma
Sure.
Data Viewer is from sgma.water.ca.gov is the website where it comes from.
Okay.
And you can
Thank you.
report out a bunch of different information from that website, but it's another state
Got
of
it.
California reporting system.
Thank you. You would think I knew. I worked on Sigma. We did not have sigma.water.gov at that time.
Kinsey, this may be my well that I let the DWR actually measure. It says Bailey and Grimes Road. It's right there. And DWRs comes out and measure it twice a year. Kind of looks like that profile, but just I guess from way background, the DWR comes out to my south well, which is right at Bailey and Grimes Arbuckle Road.
Mr. King, this is not the time for testimony. I'm just trying to pin down what these it's an evidentiary objection. So thank you. That may be appropriate for rebuttal, but I'm trying to pin down and have a fair opportunity to understand where these exhibits came from, and what they're, not the substance of what they're showing me, but where they came from and who created them. And that is helpful. Ms. Mullen, can we go down to the next page, please? And then keep going. This appears to be from the same source, roughly. And then, Mr. Ornbaun, is this?
That one's from the Bureau of Reclamation. That's a well that on Ori Farm. That's been monitored since the drought in the 70s.
And let's go to the next page, please.
That's also monitored with the Bureau of Reclamation. And it shows where the well is and the water levels.
Thank you. Let's continue. If there's more. That looks like, I believe that's the end. Thank you.
Yeah.
So I think the way to handle this, I'm not going to rule on each of these right here on the fly. I just wanted to walk through them and talk about them. Well, let's say, Ms. Chester, you had indicated that Ornbaun 16 was somewhat similar. So Ms. Mullen, can you please bring up Ornbaun 16? And this looks like 11 pages. Mr. Ornbaun, can you explain to me the difference between Ornbaun 4 that we were looking at and Ornbaun 16?
Yes, it's a different time. So this was in February 23, just showing different flows for different months of different years. So that shows our higher flow in March and April. To help them understand the flow of the Coosa Basin drain, and it can have very high flows in any month of the year.
And then I think based on those two, Ms. Chester, is there anything you wanted, anything specific? Well, let me ask, Mr. Ornbaun, is there anything you would like to add with respect to the evidentiary value of these, not in substance, but where you acquired this information or acquired this data?
That data is, again, from the Bureau of Reclamation website.
And then the other data was from the sigma.water.gov, it looked like, webpage.
Correct.
Thank you. Ms. Chester, is there anything you would like to add with respect to your objections on these two, Ornbound 4 and Ornbound 16?
Yes, we would maintain our objection on the basis of a lack of foundation. These are unidentified excerpts, not cited or otherwise relied on in the case in chief evidence. We wouldn't necessarily have an objection to public records or documents, but it's not clear that we can read or identify either the information provided or the source of the information in these two exhibits. We also don't have a basis for testimony by an expert witness to speak to the information intended to be provided by these witnesses for purposes of the witness testimony.
Mr. Schutz, please.
Sorry, I don't mean to interrupt, but I believe Mr. Ornbaum this seems to be from CDEC, and Mr. Ornbaum addressed that or attributed that to the Bureau of Reclamation. It's actually a Department of Water Resources website, and I just wanted to clarify that for the record.
Thank you.
If I may, I appreciate the willingness to support Mr. Ornbaum, but this is about the exhibit submitted by a witness in furtherance of his testimony, which he is speaking on behalf of. And so while I appreciate the support, it doesn't change the basis of the objection.
Just pointing out a matter of fact, not speaking to the objection itself. Thank you.
And I appreciate that, Mr. Schutz. Thank you. Let's go ahead and step through. If we can bring up Ornbound 6, please. So, Mr. Ornbound, what is this?
I'll have to, let me see the bottom part. It says table of contents, but I think it is.
We scroll down, Ms. Mullen, please.
Well, like what it says there on the bottom, scroll up one, map of California showing the Sigma medium high priority basin highlighted in blue. The sub-basins and the subject of this report are highlighted in red. So if we scroll down a little bit more, too far.
But what is this a copy of? What is this report?
It's a northern Sacramento Valley sub-basins.
But who authored this document, and where did you get it?
I got it from Sigma, map of California showing the Sigma webpage.
So it's a report that was on the Sigma webpage somewhere.
Yes. It was under my discovery, trying to show that we are in a deficit in the area that I'm trying to protect. That's why I'm just trying to show other evidence.
All right. Ms. Chester, do you have anything you would like to add to your objection on this one?
Yes, this is again for lack of foundation. There's no underlying factual basis. This is an unidentified excerpt, not cited or otherwise relied on in his case in chief testimony. There's no basis in the testimony to support that this is related to an expert opinion of the necessary knowledge, skill, expertise, or training for purposes of an expert. It also appears to be irrelevant to the opinions provided in the testimony, and we would also argue that the probative value of these excerpts is consumption of undue time versus their probative value.
Thank you. Mr. Ornbaun, do you have the first page of this report?
No.
Okay. So this is my challenge again, and this you can think about this going forward, because you will have another chance to submit rebuttal evidence, is that I'm now looking at a report and I don't know where it came from or who authored it. I think you told me it came from the Sigma webpage, but that
Well,
makes it very difficult, you understand, to
Yeah.
it-
I was trying to acquire information to back up what I'm saying, not just my words. I'm trying
right.
to show where we have deficit. I know the water table is 50 feet lower than it used to be. So, but me saying that is not fact. Isn't accepted by the court. I don't believe. I have to show it and prove it.
But, and Mr. Ornbaun, no, I appreciate your submission here. What I would ask next time is please be sure to include a cover page, so we know what it is and where, and to verify what the document is, because to some extent, official records such as official government reports can be admitted into evidence without additional support. But if I don't know what it is, or who wrote it, or when,
I understand.
it's difficult to do that. Ms. Mullen, if you would please bring up Ornbaun 7.
Hearing Officer Kenzie, while we move, my understanding based on the label attached to Ornbaun 7 is that this is a continuation of the same excerpt.
I see.
And so my objections to 6 and 7 are the same.
Thank you. And Mr. Ornbaun, is that right? Is to your
I believe so.
recollection?
Yeah.
I'm sorry. I think we talked together. What was that?
Yes, I believe they're hooked together. I'm just showing subsidence and lack of groundwater, lowering of groundwater, evidence for that.
Thank you. Let's go ahead and go to Ornbaun 9. And if we can scroll down a little bit, Ms. Mullen, to see if there's any identifying information at the bottom here. Oops, tricky one. All right, Mr. Ornbaun, where did this exhibit come from?
Well, it says the source member agency boundaries were obtained from the California Natural Resource Agency website 2020. Agency boundaries not included in the data set were obtained from other sources. That's what it just says on the bottom, reading from the bottom of the page.
Thank you. But do you know what report? It looks like this maybe came from a report that was compiled by possibly an agency. Do you know where it came from? What report?
I'd have to.
You're not sure sitting here where you obtained this?
I'd have to read it ahead. And what's on the top? What does it say on the top?
Ms. Mullen, if we can please scroll out. I think it just said draft. But let's see. So this looks like, there we go.
It's from the
Ms. Kenzie, I believe it's at the bottom. I believe it says the Calusa draft groundwater sustainability plan on the
Oh,
right.
did we miss it? Oh, thank you.
Bottom
Let's
right.
go ahead and scroll down.
probably from the Calusa Subbasin GSP.
There it is.
If we scroll down anymore, it's going to jump up. So it may, and I can open the document separately and I will take a look at that.
It's there on the bottom right, ma'am.
I see Calusa GSA and Glen GSA. And then but I can open the exhibit on my own screen so that I can see it. So Mr. Ornbaun, do you remember, this document may have been something that you took from the web page of possibly the Calusa GSA or the Glen?
Yeah, I think it would be
GSA.
they filed together for their right, so or for their GSA documents. So yes.
Understood. Thank you. And then Ms. Chester, do you have anything to add?
Yes, this is continued. It continues on with other excerpts that are not labeled or identified. Again, we would object on the basis of a lack of foundation, inadmissible testimony by an expert witness, and irrelevant.
Can we, Ms. Mullen, will you quickly just step through a couple pages here further? And so I'll pause here. Mr. Ornbaun, do you remember, were these excerpts taken from the same document, all from the same report?
Yes.
Okay, thank you. Let's go ahead and go to Ornbaun 13, please. And Mr. Ornbaun, will you very briefly describe what this letter is, please?
It's my response to Jerry Brown, or it's from, yeah, it's from my response to Jerry Brown, from the response when we had a meeting.
Thank you. And then Ms. Chester, is there anything you want to add with respect to your objection to this document?
Yes, my understanding from review was that this document is related to, or correspondence related to, the protest submitted by Mr. Ornbaun. And for the reasons that we submitted in objection to the AHO exhibits, similarly including protests, this would be a part of that objection.
Thank you. Let's go ahead and go to Ornbaun 14, please. And Mr. Ornbaun, what document is this? Where did this come from?
This is from the USGS that's they do soil surveys, and it shows the soil types, and it shows the each soil type will have its own definition. And in the continuing pages, I showed the soil types along the basin drain around College City and Arbuckle to prove of water infiltration capabilities for groundwater recharge.
And so this is a document that you, or a report that you pulled
I
from
have physically have a book for the county. It's every soil type in our county.
But you got it from the USGS webpage?
Yeah. Yes.
All right, thank you. Oh, Ms. Chester, did you have anything to add to the objection here?
No, I understand the allowance of public documents into the exhibits, but our objection again was on a lack of foundation, inadmissible opinion testimony by an expert witness, and irrelevant.
Understood, thank you. Let's go to Ornbaun 15, please. Right, Mr. Ornbaun, and if we need to scroll down so you can see, remind yourself what this is, but do you recall where this information came from?
That's from the same book. It's just continuance of facts of the soil types in those areas.
All right, so it's from the same report or
Yes,
compilation as Ornbaun 14?
multiple pages to show each. So then when you go to scroll down a little bit more, scroll up. It shows you, it references the pages and then references the soil type. So then if you continue in the book, it will explain each soil type. And then the pages are backing it up. They're behind.
Thank you.
In other words, this On the heading, this is a list of some of the overlying soils under Clues Basin drain in the areas west of Arbuckle and College City, south of Sycamore Slough. So I'm just identifying soil types that have been done by USGS.
Thank you. Let's go ahead and go to Ornbaun 16, please. Oh, we already did 16. I'm sorry.
Well,
We already addressed that one.
But that water, that's okay, Ms. Kinsey, that water flows over those soil types. There is correlation between those 2 pages.
Thank you. And then I think
My last objection was to Exhibit 11, the written
Right.
testimony on the basis of inadmissible opinion testimony, either submitted by an expert or in the alternative, a lay witness.
understood. And Mr. Ornbaun, just to clarify for the record, your written testimony that we previously had on the screen or earlier had on the screen, that testimony is based on your personal observation and knowledge, as well as your experience as a farmer in the area. Is that correct?
And also the documents of the water flows in the basin and the soil types. That's the backup of my knowledge.
Understood. Thank you.
I don't know how to, it's not a place for me to, but I know and I've seen when the water flows and where it goes. When the river's up or the canal's up, I can tell you, well, this water is going to flow here. It's going to come out over there. I know where it is. I understand where the water goes. And when it goes down, I understand where the water goes. So I don't know. I'd be glad to answer any questions they have to question my expertise at any time.
Thank you, Mr. Ornbaum. I think that this was helpful for me to step through this. I'm not going to rule on the fly at this point. We will wrap in rulings on the evidence at a later time. And what will happen, Mr. Ornbaum, is that I will issue a ruling that will clarify these exhibits are coming into the record, and if any are excluded from the record, there will be a ruling as to why. One of the things I did want to explain is that often in evidentiary rulings, I will say that this document, I might say this document is excluded, but without prejudice. And what I mean is that I don't mean that I never want to see this document again, but if there was a flaw, for example, if the document is excluded because there is a lack of information about where it came from or substantiation of what the document is, if it's excluded without prejudice, it's something that if it's appropriate and it responds to the authority's case in chief, it's possible you could submit it on rebuttal. So I did want to explain that piece of this, that this is not, I will make rulings on these exhibits, but it's not to be taken as necessarily I never want to see this document again. It may be just as a procedural matter that it may need to kind of a second.
It's outside the possibility of remedying the situation.
Right. Yeah, that is
critical.
exactly what I mean to say. Yeah. So thank you, Mr. Ornbaum. I believe with that, Mr. Busher, please, you have a hand.
Well, I have one comment here. Just in terms of the foundation objections, if the hearing officer is considering sustaining those or excluding, I just think it would be appropriate to give Mr. Ornbaum the opportunity to submit the, title, author, date, and website for any of those documents. I'll let him address the other objections to the extent there's more, but that would seem to cure a lot of the foundation questions.
Understood. Thank you, Mr. Busher.
Thank you.
I'll think about how to go about this. But I think with that, Mr. Ornbaum, I appreciate your testimony today. I appreciate your participation as a non-lawyer and with somewhat or fairly complex legal proceeding. As I said, there will be a later evidentiary ruling on all of the objections that will lay out what is in the evidentiary record and what has been excluded. Are there any questions I can answer at this point about that process or about next steps?
Probably just how would I become an expert? I would be glad to go ask any questions or explain anything. I don't know if I had a degree, I'd be an expert. If I was a lawyer degree, I'd be an expert. I'm not sure how that works.
There's a complicated legal standard and the rules for expert testimony do apply to some extent in these proceedings that to offer an opinion about certain issues where it's not your direct observation, it's not based on your direct observation, then expertise in the subject matter has to be indicated. That does not necessarily require a degree. It can be based on a lot of reasons that you have particular and specialized knowledge about an area that would not be true of your average person walking down the street. So there are many ways to do that. However, in these proceedings, what is generally asked for is a resume or some kind of documentation of expertise, but it doesn't to support your position as an expert. But you can also testify in these proceedings as what we call a layperson, but as a non-expert. It's somewhat of an evidentiary distinction. Again, it's something that possibly could be remedied. Not necessarily. Remedy makes it sound like that I have found the rule that there's a flaw here. But if there were a flaw, that could possibly be remedied in the future by including with with a person's expert testimony information about their expertise or experience or knowledge to substantiate why that person has particular unique knowledge about the subject matter.
Okay. I have
yeah.
particular and unique knowledge for that area.
Yeah.
Okay.
Anything else I can answer about process? Okay.
If all the ones all those statements they don't like, I'll be glad to find, I will identify exactly where every piece of information came from if I didn't supply it.
Thank you. I'm going to think about how to address this on next step. I don't know that this needs to be complicated, so I'm going to pause. But if I need more information from you, we will communicate by email, which of course would be CC to the service list.
Thank you.
That would be the intent.
Thank you.
Thank you. Thank you, Mr. Ornbaun. Thank you for your testimony today, and thank you for participating and taking the time to participate in this proceeding. With that, you are excused. I would like to, I believe this, since we're on a roll, well, let's go ahead and take a break. It's about time for a break. When we come back, what I'd like to do is address the objections to Mr. King's exhibits. Well, allow Mr. King to make a formal offer of his exhibits, and then we can address any objections in a similar manner. And so that we can do that orally. And then once we get through that, my intent would be to turn to Dr. Rosenfield. Before we break, are there any concerns with that process or anything else we should think about? All right, let's take 10 minutes. We'll come back at 10:38. Thank you. Welcome back. I'll look to our court reporter. Are you ready for us to go back on the record?
Thank you.
Thank you. I believe where we left off is to turn to Mr. King. And let me prepare myself here.
For some reason, I can't turn on my video.
See,
Is there any reason? Oh, here, start. Okay, I have something. Okay, you stopped it before, so now I'm on. Thank you.
Great, thank you. I'm just pulling up your exhibits here. So, Mr. King, do you offer into the evidentiary record exhibits King 1 through 75, including King 67A, which is I understand, an errata of update of your statement of qualifications?
Yes. I have to look at what 74 and 75. I don't have a recollection of what it was 74 and 75 is. Can you remind me what that is? I just looked at.
So 74, these may have been exhibits that I'm just trying to get your intent of what you intend to offer into the.
Oh, I intend to offer all my exhibits and the protest, which is AHO 292. So all the.
Thank you. And King 74 appears to be, and just to refresh your memory, appears to be an email from Brian Thomas to JP Robinette dated November 17th, 2023. Does that refresh your memory?
Yes.
And then King 75 is labeled as your opening statement.
Yes.
Okay.
Thank you for the clarification. I just looked at on my documents and I didn't look at the most recent. So
and I will say, and so we can cut through this, the opening statement, that is I think as you understand, it's not an evidentiary submittal. So that
absolutely.
my intent would be to exclude it from the evidentiary record, but it would be included in the administrative record.
That was never my intent to actually include that in the evidentiary record. I always understood to be part of the administrative record and appreciate the opportunity to make it and submit it for that purpose only.
Okay, understood. Thank you. And so we have clarification at least on King 75. I know there were written objections from the authority to a number of these exhibits. I will look to you, Ms. Chester, to very kindly summarize those. I did read the objections, but I don't have the document open in front of me. And then, Mr. King, I did see that to some extent you responded with respect to the objection as to your expert qualifications. But Ms. Chester, will you please summarize your objections to Mr. King's, not yours, but the authority's objections to Mr. King's exhibits?
Sure. So we objected to King 1 through King 66 on the basis of inadmissible opinion testimony, lack of foundation, and relevance. We objected to King 68 on the grounds of inadmissible opinion testimony, and the amount of time outweighs the probative value. We objected to King 69, as that was an exhibit that was previously denied for inclusion even in the administrative record, as I understand it, from the hearing officer. King 73 was also already ruled on by the AHO because it was untimely submitted. We objected to King 74, which was another exhibit untimely submitted by email. And then, although you have just resolved it, we objected to King 75. And then we would also add an objection to the exhibits and to the extent that it's intended as testimony to the email that Mr. King submitted as his qualifications more recently, I believe, in October.
And I know the email you're referring to, yes. Thank you. I want to make sure I understand the objection here.
If I may, I don't think it would be a particularly good use of our time to click through the 60 or so
No.
objections. I'm happy to discuss in more detail the types of documents that we're objecting to and describe the basis.
Well, and I wanted to ask that, what do you mean by inadmissible opinion testimony if it's not being submitted as testimony?
It's inadmissible opinion testimony by an expert witness. Mr. King designated himself as an expert, but there is no basis in the written testimony to support that he has the necessary knowledge, skill, experience, or training or education to testify in the form of opinions as permitted pursuant to Exhibit Code. I believe it's 80, let me get my number right, 801. And we don't have enough information to confirm that he has the personal knowledge or perception to testify to all exhibits relevant to Evidence Code Section 800, as well as Section 702. So generally, we've included both of those bases of objections in our written objections.
Thank you, Ms. Chester. And I understand that with respect to Mr. King's testimony, which I believe is King 68. But with respect to King 1 through 66, I thought you said that the objection was based on in part on inadmissible opinion testimony, and I didn't understand what you meant by that.
Sure, understood. So King 1 through 66 include public records, but also documents that require some level of expertise, whether legal or specialized hydrological understanding to interpret and provide opinion testimony on. So if they are intended to support or provide the bases of the opinions in his written testimony, I think it's in conjunction with our objection on the basis of lack of foundation.
Okay, understood. And then Mr. King, would you like to respond?
Okay, so regarding qualifications, I understand they're objecting to my updated qualifications, and all I did was add the word pass to my role as chair of the SAIC committee for the Almond Board of California. That was the only change. So I didn't understand why they're objecting to my amended qualification. Was that the reason why you're objecting to it, Ms. Chester?
No, we are not objecting to King 67 or King 67A. Our objection is to the email that was submitted with additional attachments that you submitted in response to our objection on the basis of qualifications.
Oh, okay. So I missed. Okay. All right. So then regarding my qualifications, as far as expertise, so I have personal experience since my family's owned this property since 1869, which is the riparian area, which is the subject of the diversions that I'm protesting on, the riparian and the four appropriative rights. And I've been managing that property since 1971 when my father died. When I'm 65 and I was 12 then, so it's over 50 years of personal experience and understanding the hydrology and the ecology of that area. Although I'm not a practicing attorney, I did graduate from King Hall, UC Davis School of Law in 1986. I did practice, not a litigator, but corporate law, and I understand contracts. And I didn't put that in, but I do put it in that I am a graduate of King Hall School of Law. So I believe I have the ability to have the expertise in legal matters. Regarding hydrology, I have been chair of the SAIC committee for the Almond Board of California, which oversees the research budget of about $4 million for 1.3 million acres of almonds in the state of California, about 8,000 growers. And I've been on that committee for about 4 or 5 years. One of our focuses is hydrology. I was a member of the Technical Advisory Committee for the CLUSA of Groundwater Authority. It's a joint committee between the Coosa Groundwater Authority and the Glen Groundwater Authority, and was part of the process approving hydrology and other sustainability indicators for the 2021 submission. And I've been an active commentator around hydrology and regarding many issues and water quality, specifically between the Water Board, the California Water Commission, the Groundwater Authority. I'm a director of the Coosa County Resource Conservation District, which also has issues of water quality and hydrology. And I'm a certified California naturalist, which is certified by the UC Department of A&R. I co-authored a on-farm recharge paper with
Mr. King, I did read your email. I
Yeah.
think, and this is all in there. And so I do understand that you had these responses in writing and you responded to the authority in writing at that time. Is there anything else you would like to add at this time in terms of your?
Oh, no, I mean, they're objecting. I just want to be complete because they're objecting to my qualifications. And so that's my expertise. Regarding, should I respond regarding certain exhibits, or is that, do you want
You
more?
may respond yes, you may respond with respect to particular exhibits. I was going to step through I think 69, 73, and 74 just to make sure I understood them separately, but with respect to exhibits 1 through 66.
Yeah,
Go ahead.
So my first thing is it's a gigantic overreach, and since the area of origin issues and county origin issues are so important, and I'm the only protestant that actually has insular right to actually make those assertions, I think it'd be very prejudicial to your proceedings if you granted exclusion of anything, especially anything that I brought in a cross-examination. And I was limited on cross-examination, so I would hope that you give him a little more leave of consideration of bringing this evidence in. Almost all of it is other documents, public documents. There are some excerpts, but the only one I can really think of that is maybe hard to access is the 1871 history of Coosa County by Will S. Green, because those copies are not easily attainable, but you can get it in the California State Library, which I regarded. So I just think it's a gigantic overreach and kind of discredits their even assertion. It's kind of absurd that they're trying to limit the evidence I'm trying to bring in and then attack my qualifications. So I think that's just indicative of how absurd their objections are. So I think that's that, and then we can get into particulars of the other exhibits. I would mention that I am in support of sites and all the parties bring their exhibits, and I would mention that one of sites exhibits, the authorities exhibit, is the Coosa Groundwater Sustainability Plan, the 2021 submission, and that includes some of the exhibits that Mr. Ornbaun brought in that figure that 2-4 of the different districts. That's part of that sites exhibit. So for your reference, that has already been asserted, brought in evidence by the sites authority themselves. I don't know if you understand that, but they did, I believe they did include the groundwater sustainability plan. Mr. Davis referred to it several times. And that I think with the different districts, that is part of that sites exhibit.
Understood. Thank you. Let's see how should I do this? Well, I guess I'll give Ms. Chester, did you have anything that you would like to respond to with respect at least to exhibits 1 through 66 and 68?
Yes, so I do understand that there is some overlap in the submission of exhibits in 1 through 66, including I think AHO exhibits as well as sites exhibits. That really only furthers our position that they are not necessary for submission. Mr. King argues that it would be prejudicial because he is the only participant who is a certain right holder, but the testimony and the supporting exhibits do not go towards those rights, they don't relate to those rights. This is again specific to the fact of a failure to show expertise or personal experience necessary for purposes of providing the opinion testimony offered.
Can I respond to?
You may, yes.
So my intent was that the one reason I want to include the protest in is because that established particular rights, and I assumed that that would be body of the evidence or record since it's included in the AHO exhibits, and did not include it in my exhibit, and didn't feel that since I knew I had limited opportunity testimony, I focused on environmental issues and area of origin issues, and I believe the area of origin issues are not only exclusive to my water right, but my water right is necessary for me to assert those area of origin issues, and I focus on more general sustainability issues and area of origin issues regarding the environment and beneficial uses of the riparian habitat that we own and also is adjacent to our property.
Thank you, Mr. King. With that, I would like to, and again, I'm not going to rule on the fly on these issues, but this, I did want to have a chance for this oral discussion, given that you had requested, Mr. King, the opportunity to orally respond.
Thank you very much.
Would like to briefly step through just to make sure I understand 69, 73, and 74. So I'll turn first to Ms. Chester, and maybe Ms. Mullen, can we pull up King 69 just so we know what we're talking about? So my recollection is that King 69 was submitted in August, so after the deadline for the submission of case in chief testimony. I believe I did not accept it into the record on that basis. What I don't recall is whether King 69 then returned as a cross-examination exhibit or in any case. So I will look to both of you to help me refresh my recollection of where we are on these. Ms. Chester, is my summary of the history of King 69 to your understanding? Does that match?
Correct. You ruled on September 3rd, on pages 1 through 3, that the King 69 could not be admitted into evidence during the case in chief portion of the proceeding. My understanding is that related both to direct and any cross-examination because it was late filed and not submitted specifically in reference to any specific cross-examination.
Thank you. And then Mr. King.
Oh, yes. So my
ahead.
recollection is that you ruled that it couldn't be admitted because it was after the deadline, but you allowed me to bring it in on a cross. And it was, I believe, I disagree with Ms. Chester that it relates to cross. I did bring it in on cross, and it was part of the testimony for panel 1. And I know Ms. Forsythe actually acknowledged receiving that and seeing that, because at the end of the exhibit actually is an email from several members of MBK, who are the consultants for the Sites Authority, and one of the panel members was a part of that panel too. She's an MBK person, so it came in on cross, and that's another. Generally, I brought a lot of 1 to 66 in a cross, plus King 69 came on a cross.
All right, I can investigate further on the. I think I remember that. It was a long time ago.
Yes.
a lot of hearing days ago.
Yeah.
Thank you for that reminder. And then I'd like to move on to King 73. Please, Ms. Mullen. And this, I believe, so this was something submitted that you submitted, Mr. King, and it appears August 27th. Did you use this document on cross-examination?
Yeah, so I tried to bring in King 64, and the question was whether or not there's appropriate foundation for King 64. It's the end of my cross of panel 1. And if you scroll down, if you could, the key point of this is some commentary. It was a response of Mr. Robinette and Mr. Brown about whether or not they have seen King 64 before. And at the last part, if you go down to, it's a page, go down a little bit farther. This is the email chain. But going, yeah. So I actually introduced the foundation as being from Mike Urkoff, and I knew that that it was I got it available from public records request from, and this is email chain. So if you go up from a timestamp, you see that this is from Mr. Urkoff to Doug Brown, who is the bond counsel for Sites Authority. And then in the beginning, you see that this was actually
So Mr. King, I don't want to get into the details of what the substance is, but so you submitted
so
this
73, yeah. So 73
73.
was to show the foundation for the inclusion of Exhibit 64. And at the time of the hearing, you didn't allow 64 to come in. And so I think what the status is now, you need to make a final decision about whether or not 64 should come in. And this was to actually show the foundation, but also impeach if you go back and look at the testimony of Mr. Brown and Mr. Robinette about whether or not they had knowledge of this.
Well, let me pause you right there, Mr. King, because it sure sounds to me some of these are going to be, I don't need to do extra evidentiary rulings. It sure sounds to me like some of this is more appropriate for rebuttal. So I'm giving you a forecast of what my ruling might be, but then we can avoid some of these issues. So once again, I will remind you of what I said to Mr. Ornbaun, which is if I rule to exclude any of these, there is it will likely be without prejudice in the sense that you may attempt to bring the document in through the rebuttal process if it's appropriate rebuttal.
Yeah, I think that's, given where we are, I think that's reasonable. I would just ask that I would have the time, to actually to exercise my rights for a rebuttal. I realized I wasn't so efficient at the beginning of this proceedings, but I would hope that you find the body of knowledge I brought to the proceeding helpful to your, especially if you approve it with conditions. But my concern is I'll be limited again on rebuttal, and I believe that my ability to have a time for rebuttal is really important for your determination of the area ordinance issues and county ordinance issues.
Thank you, Mr. King. And I will be setting separate time limits for rebuttal. Separate from that, though, you can submit rebuttal exhibits without taking any time. So you can keep that in mind.
Yes.
Right.
So if you could just clarify whether or not I need a reset. I think my understanding is that I don't need to if they come into the evidentiary record at this point, I don't need to resubmit them. Is that correct?
If they're admitted, then they're in the evidentiary record. If they're excluded, for example, for procedural reasons, because the exhibits were late filed to be case in chief exhibits, you could offer them as rebuttal exhibits, and then we would consider them as rebuttal exhibits and rebuttal evidence through that process.
And you'll let me know before the time period for the
yes.
Right? Okay. Yeah. That's
we will have evidentiary rulings before, hopefully well before the deadline for submitting rebuttal evidence, so that everyone can know how to respond and what evidence is in the record so far and what is not yet or is excluded.
So fair enough. Yeah.
And then and Ms. Chester, I'll give you a chance also to chime in, but I thought it would be helpful just to step through these and you can address them as a block. But King 74, if we can please pull that up, Ms. Mullen. And I believe
this is the same thing. It just shows you that Mr. Robinette actually, my assertion is that Mr. Robinette didn't have a chance to refresh his memory about his knowledge regarding Site 64, the King 64. So we get same issue. Yeah, but more email that I came in.
Thank you. And with that, I will turn to you, Ms. Chester. Do you have anything else you would like to add to your objections?
Just for clarification, King 64 was excluded as a cross-examination exhibit. It was on an objection that was sustained by the AHO. So the submission of King 73 and 64 for the submission of that exhibit for purposes of cross-examination is irrelevant. I don't think a further ruling is needed, but at this time, we're also objecting to the inclusion of those two exhibits, which were late filed on October 3rd and 9th, respectively, to the service list.
Understood. Thank you. And understood. And thank you, Ms. Mullen. I think with that, we've had an opportunity to step through this. I want to work through these carefully to make sure we get all of this right, but I think I have the information I need. As a final word, Mr. King, if you would please be brief, but is there anything else you have to add in your response to these objections from the authority?
Thank you for your time and consideration.
Thank you. Thank you, Mr. King. And thank you, Ms. Chester.
If I may, I will just note that we included our objection to AHO 292, which Mr. King has requested be moved into the evidentiary record. That was specifically included with our objection to the AHO exhibits.
Thank you. That's helpful. All right, with that, it is 11:06. My inclination would be to go forward with a summary of testimony from Dr. Rosenfield, but are there any other procedural issues that we should address at this time before we jump into that next effort? All right, then I will look to the coordinating NGO parties, if you will. Looks like Mr. Busher, are you prepared to introduce Dr. Rosenfield?
Yes.
And I will go ahead and administer the oath, and then we'll get started. If you would please, Dr. Rosenfield, raise your right hand. Dr. Rosenfield, do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Please, go ahead, Mr. Busher and Dr. Rosenfield.
Could you please state your name for the record?
Yeah, my name is Jonathan Rosenfield.
Is Baykeeper Exhibit 2 a true and correct copy of your CV or statement of qualifications?
It is.
Can you just very briefly describe your background and experience as it relates to your testimony in this matter?
Yeah, I have several degrees in natural resources ecology and management and biology, and have worked in the Bay Delta watershed on fish conservation issues for over 30 years on and off.
Thank you. Is Baykeeper Exhibit 1 a true and correct copy of your written testimony in this matter?
It is.
And did you prepare that document?
I did.
Are Baykeeper Exhibits 3 through 121, as well as Baykeeper Exhibit 124, true and correct copies of materials that you referred to or cited in your testimony?
They are.
And is Baykeeper Exhibit 125 a true and correct copy of the July 2024 final rule published in the Federal Register listing longfin smelt as a federally endangered species?
It is.
Did you prepare a summary of your testimony?
I did.
And is Baykeeper Exhibit 123 a copy of a presentation that goes with that summary?
It is.
Ms. Mullen, if you could put Baykeeper 123 on the screen, and Dr. Rosenfield, whenever you are ready, please go ahead and summarize your testimony.
Thank you. Good morning, everyone. My name is John Rosenfield. I'm the science director at San Francisco Baykeeper, and I'm happy to provide a summary of my written testimony. The summary of my summary is that the San Francisco Bay estuary and the main rivers that feed it are in ecological crisis. Changes to river and delta hydrographs are the primary driver of declines in fish, wildlife, fisheries, and water quality. Site's reservoir will divert flow from the Sacramento River and deny much needed flow to the Delta and San Francisco Bay estuary ecosystems. Although its operational plans call for diversion only of quote excess or quote surplus river flows, the flows that site's reservoir proponents define as excess or surplus are well known to provide vital ecological services. For this reason, I do not support building or operating site's reservoir, as it will necessarily harm species and water quality and related beneficial uses that are already severely compromised. However, if the project is permitted by the Water Board, its operations will need to be constrained in order to minimize the harms it will cause. My testimony describes the scientific underpinning for those additional conditions. Next slide, please. Over the past 15 years, this water board has declared many times that the San Francisco Bay estuary is in ecological crisis. Most of the slides I'm presenting today display quotes from the water board and other state and federal agencies acknowledging this crisis and the need to improve river flow conditions to avoid continued severe negative outcomes. I won't read from them directly. Next slide, please. Evidence of the bay's ecological crises abound. For example, native fish and wildlife species are declining and increasingly imperiled. 7 native fish species are currently protected under the state and federal Endangered Species Acts, including winter run Chinook salmon, Delta smelt, spring run Chinook salmon, Central Valley steelhead, green sturgeon, longfin smelt, and white sturgeon. These species are all either at high risk of extinction or high risk of becoming endangered. Declines of each of these species are linked to reduced flow in Central Valley rivers and/or through and out of the Delta. Another crisis related to unsustainable diversion of river flows is the closure of and increasing constraints on fisheries that are economically, calorically, and culturally important. For example, this summer, the California Fish and Game Commission made California white sturgeon a candidate species for CISA listing based on evidence of the fish's decline in the San Francisco Bay watershed. This led to the end, at least temporarily, of recreational harvest of white sturgeon. Other closed fisheries include those for each of the listed species. The California coastal Chinook salmon fishery, which relies on Central Valley production of Chinook salmon, has been completely closed for the past 2 years. Fisheries for bay shrimp and starry flounder are also negatively impacted by storage and overdiversion of runoff bound for the San Francisco Bay estuary. Next slide, please. The Water Board is not the only agency that recognizes the ecological crisis in the San Francisco Bay estuary and its relationship to unsustainable management of river flows. US EPA stated this year that, quote, scientific consensus indicates that native fish population abundance is positively associated with flow values, end quote, and that they also noted that large-scale increases in flow will be needed to recover and protect native species. Additionally, water quality has suffered from unsustainable storage and diversion of Central Valley river flows. For example, harmful algal blooms, some of which are highly toxic, have proliferated. Research from across the world and from within our own watershed indicates that blooms of toxic microorganisms, known generically as harmful algae blooms or HABs, are facilitated by reductions in river flow. Here, I want to emphasize 3 points about the bay's ecological crises. These declines in viability of imperiled species, fisheries, water quality, and related beneficial uses of water are ongoing. The status quo is decline. Maintaining current conditions will lead to continued long-term declines. In this context, even seemingly small negative effects likely represent acceleration of the underlying long-term decline in conditions. Number 2, statistical magnitude does not always reflect the biological magnitude of an impact. Given the precarious state of the Bay Delta ecosystem, even seemingly small negative effects have outsized impacts, and site's proponents have not documented all the potential effects of proposed operations. The The risks associated with increasing diversions are asymmetrical to the potential benefits. The consequences of continued decline in Bay Delta ecosystem conditions include the permanent loss of species and related beneficial uses and ancient cultural practices. Human alteration of river and delta hydrographs are the primary driver of declines in a wide variety of fish and wildlife populations, fisheries, and water quality metrics. The scientific record is extraordinarily clear about the strong and widespread connections between viability of native fish and wildlife and river flows into the San Francisco Bay estuary. By viability, I mean population attributes that contribute to persistence in the wild, including population abundance, productivity, spatial distribution, and genetic and life history diversity. A wealth of peer-reviewed scientific studies published over the span of decades documents the statistically significant, strong, and durable positive correlations between fish population viability and flows into and through the delta, particularly in the winter-spring months. Long-term increases in diversion, including diversion to storage, have significantly modified the timing and volume of river flows into, through, and out of the delta. The size and number of dams and water diversion infrastructure that prevent runoff from reaching San Francisco Bay have increased substantially over the past century. This infrastructure, combined with growing demand, has led to an ongoing decline in the portion of available runoff that makes it to and through the delta during the ecologically critical winter and spring months. Declines in the proportion of unimpaired Central Valley runoff reaching San Francisco Bay has continued despite increased regulation of water diversion and exports, even following implementation of the 1995 updates to the Bay Delta Water Quality Control Plan. Water Board staff described this reality in 2023, stating, existing regulatory minimum delta outflows would not be protective of the ecosystem, and without additional in-stream flow protections, existing flows may be reduced in the future, particularly with climate change and additional water development. End quote. Next slide, please. California's Department of Fish and Wildlife has recognized the important role of increased water diversions in driving decline of ecologically and commercially important aquatic species, stating that current delta water flows are not adequate to maintain, recover, or restore the functions and processes that support native delta fish, or migratory fish like Chinook salmon. Next slide, please. I'll skip to the next slide, please. Thank you. Flow has its beneficial effects on attributes of fish and wildlife viability through multiple secondary and tertiary mechanisms. For example, river flow rates affect access to important habitats, prey abundance, river temperature, currents, and other environmental conditions. In many cases, the mechanisms involved change during the life history of the organism in question. Next slide, please. And one more slide, please. In the interest of time, I won't go through all the possible mechanisms and research into those mechanisms, but I will note that both the Water Board and EPA identify flow as a master variable governing environmental processes in rivers and estuaries, such as the Bay Delta ecosystem. This means that river flow is the primary driver of numerous other stresses on fish and wildlife populations and water quality conditions. State and federal agencies also acknowledge that current flows are inadequate to protect the Bay Delta ecosystem, and that flows must be increased substantially to support aquatic life and beneficial uses. And both the Water Board and EPA identified as urgent the need to improve protections of river flow and delta outflows. As EPA states, swift action is needed to address the imperiled state of the delta and the species, communities, and economies that depend on this ecosystem for survival. Next slide, please. Another point that I want to emphasize is that there is an obvious disconnect between agency findings with respect to the best available science and the management response to that science. Despite the agreement of multiple agencies that the Bay Delta is experiencing ecological crises, that the primary driver of those crises is unsustainable water diversions, and that dramatic improvements in flow protections are urgent, existing regulations don't even begin to solve the problem. Species continue to decline as the necessary protections under various laws are either delayed or weakened. The administrative and empirical records show that management responses to degradation of beneficial uses and the public trust have not conformed to the flows that science indicates are needed to protect and restore this ecosystem. Next slide, please. Site's reservoir operations propose to divert more water from the watershed and to further alter the timing of those flows. Site's proponents claim that their project will divert only, quote, excess or, quote, surplus river flows. To be clear, any additional diversion of water from the Sacramento River during critical times of year will have negative effects on the river ecosystem and ecosystems downstream. This is because many of the relationships between flow and fish viability, for instance, are linear. More flow leads to more abundant fish, increased survival, better distribution throughout the ecosystem, etc. For this reason, I do not support building or operating Site's reservoir, as it will necessarily harm species and water quality and related beneficial uses that are already severely compromised. Next slide, please. Longfin smelt, pictured here, are a classic example of the power and durability of the relationship between flow and population viability. The recent listing of longfin smelt as an endangered species provides a stark reminder of what is at stake if the Water Board continues its pattern of neglecting the well-documented needs of imperiled fish and wildlife species. When it listed the bay's population of longfin smelt as federally endangered this summer, the U.S. Fish and Wildlife Service predicted that under current conditions, including current patterns of freshwater diversion and storage, this population had a 50 to 80% probability of extinction over the next 40 years. The service stated its belief that under current conditions, it is likely that longfin smelt will dip below recoverable levels within a decade. Next slide, please. Nevertheless, the NGO community decided to provide conditions necessary to avoid and mitigate harms of Site's reservoir if it is approved by the regulatory agencies. I evaluated Site's reservoir's proposed operations in the context of a rapidly deteriorating environmental status quo that is related to long-term trends of increasing storage and diversion of river flows. I found that much of the flow that Site's proponents define as excess or surplus provides vital ecological services, supporting beneficial uses that are in decline. River flows, in addition to the regulatory minima, are the only lifeline that has prevented complete loss of numerous fish populations and catastrophic water quality conditions in the recent past. These flows are not excess or surplus. Next slide, please. Oh, that's the end of the slides. In my written testimony, I identify flows that are critical to the viability of numerous native fish species. Above these flow levels, impacts to the relevant species may be small enough as to not affect the overall trajectory of the population. I want to note that although it is possible to identify river flows that could be diverted with limited further harm to the viability of native fish or further degradation of Bay Delta water quality, Site's operational plans would not protect these flows, and diverted flows represent an irretrievable commitment of resources that is likely to impede recovery of fish and wildlife species. And also that flows we identify as productive today are based on our current state of scientific understanding. As our scientific understanding changes, it is likely that we will learn of the need to protect flows in addition to those I identified in my testimony. I will not explain all of the necessary limits on Site's operations detailed in my testimony here, but I want to call attention to a few of the provisions to illustrate our approach of diminishing Site's negative effects by tethering its operations to the best available science. For example, the NGO coalition called for sites diversions to be constrained to better protect the extremely endangered winter run Chinook salmon. One provision would be to limit diversions during January, February, and March, when flows at each of the following gauges, Red Bluff, Hamilton City, and Wilkins Slough, are less than 700 cubic meters per second. This is because recent published research shows that survival of migrating juvenile winter run Chinook salmon increases significantly and continuously as base flows increase. Pulse flows in the Sacramento River on top of the base flows further increase survival until base flows reached approximately 700 cubic meters per second at Bend Bridge. The positive effect of pulse flows increased as base flows declined. In other words, pulse flows that sites seeks to divert in drier years are the most important pulse flows. Diversion of flows by sites would materially reduce the survival of a species that is endangered precisely because survival in the river ecosystem is too low. In particular, diversion of pulse flows that are not protected by sites' pulse flow operational scheme would harm winter run when base flows are below 700 cubic meters per second. Flows below this level are not excess or surplus from the perspective of migrating winter run Chinook salmon juveniles. An additional condition is that sites should not be allowed to divert during December if diversions cause flows at the Red Bluff gauge, Hamilton City gauge, and Wilkins Slough gauges to drop below 400 cubic meters per second. This is because published research indicates that endangered winter run Chinook salmon juvenile migration is triggered when flows exceed this threshold in the late fall and winter. Failure to attain flows greater than 400 cubic meters per second impairs migration of a critically endangered fish. Flows needed to trigger winter run Chinook salmon juvenile migration are not excess. They are necessary to support beneficial uses, including the migration use and the rare use. Furthermore, diversions by sites should be prohibited during December to April, when they would result in flows at the Freeport gauge being less than 1,000 cubic meters per second. This is because at least 2 peer-reviewed published studies show that survival of larger Chinook salmon juveniles, known as smolts, migrating through the delta, survival decreases rapidly as flows at Freeport drop below this level. Reduced survival indicates that the water diverted by sites reservoir will not be excess or surplus to environmental needs. These proposed conditions are designed to maintain survival of winter run Chinook salmon juveniles, survival rates that are already too low. Additional conditions are intended to adequately protect other fish species. Another proposed criteria would restrict sites diversions when actual delta outflows are less than 75% of the unimpaired flow in the Central Valley. The Water Board previously identified that to protect public trust values of the Bay Delta, 75% of the unimpaired Sacramento River flow needed to make it to the Delta, and 75% of unimpaired Central Valley flow needed to reach San Francisco Bay on average during the winter and spring months. Thus, the Water Board has already concluded that diversions that reduce Sacramento River inflow and Delta outflow below 75% of unimpaired are not surplus or excess from the point of view of public trust fisheries and those who rely on Bay Delta fisheries or other aquatic elements of the public trust. These examples illustrate our approach to conditioning sites reservoir diversions to limit the project's harm to Bay Delta beneficial uses and the public trust. And with that, I'll stop and take questions.
Thank you, Dr. Rosenfield. It's 11:30, so I think we should go ahead and get started with cross-examination. It looks like Mr. Hitchings, you are on the screen. Do you have questions for Dr. Rosenfield?
Yes, that's correct. Thank you.
Go ahead.
Good morning, Dr. Rosenfield. My name is Andrew Hitchings, and I represent Sites Project Authority in this proceeding. Thank you for being here today and for answering our questions. I do want to start out, Hearing Officer Kenzie. I want to note that a number of the statements and summary of testimony that Dr. Rosenfield just provided with regard to terms and conditions, they really are not expressly stated in the written testimony, nor were there slides in the summary of testimony. And so we would object that that's outside the scope of the written testimony that was provided. And it was essentially the testimony that was just summarized when we got to the last slide, where there weren't further slides to support the statements made.
All right, I'll note the objection, then I think the way to handle that would be to follow up in writing. If you have a follow-up, to the extent you have any other evidentiary objections as a result of today and the remainder of our hearing days, I think we can roll that all in together.
Yeah, that's fine. Thank you. And I think under your prior ruling, those are due by the 6th, I think.
Yes, please.
Okay, thank you. And I apologize for that short interruption. Dr. Rosenfield, have you ever previously provided testimony under oath in any water rights proceedings before the state board involving the Bay Delta watershed?
I believe that I have, yes.
Do you remember what proceedings those were?
Under oath regarding the Cal Water Fix application for a
And that was
version. Yep.
Are there any others that come to mind?
Under oath before the water board, I believe. Oh, well, no, there was a hearing regarding a temporary urgency change petition in 2008 that I believe went to the point of an evidentiary hearing and cross-examination.
And do you recall who that testimony was provided on behalf of?
That would have been provided on behalf of the Bay Institute, my former employer.
Do you recall whether you've ever provided testimony before the State Water Board under oath on behalf of any water user party to the proceeding?
I don't believe I have.
And then have you ever previously provided testimony under oath in state or federal court litigation related to impacts to aquatic resources in the Bay Delta watershed?
Yes, I have in federal court with regard to biological opinions.
Can you describe what that litigation was?
Yes, that was litigation challenging the 2019 federal biological opinion for long-term operations of the Central Valley Project and State Water Project. My testimony was in the context of motions for preliminary injunction, and I testified twice.
I recall that. I was involved in that on behalf of another party. Any other litigation, federal or state court, that comes to mind?
I've submitted written testimony, but I believe that that's what we've described as the only time that I've testified in person under oath.
And was any of that testimony in state or federal court ever provided on behalf of any water user party to the given proceeding?
Not to my recollection.
And so would your recollection be that it would have been on behalf of the Bay Institute or San Francisco Baykeeper?
One of those two parties, yes.
Okay. Based on your employment history listed in your CV at Baykeeper Exhibit 2, is it fair to say that you've spent the last 15 plus years employed by 2 environmental nonprofits whose missions include protecting and restoring the San Francisco Bay estuary and its watershed?
That's a fair statement.
And is it possible that your employment history with these organizations could bias your testimony and impair your ability to provide objective scientific opinions?
No, that's not possible.
You don't think that's possible?
I know it's not possible.
Okay. In your testimony, you use the adjective massive at several locations to describe the scale of certain environmental conditions or actions in the Bay Delta watershed. Is that correct?
I don't recall the specific adjectives that I used.
Why don't we go to, if Ms. Mullen could bring up Baykeeper Exhibit 1, which is Dr. Rosenfield's testimony, and go to paragraph 26. So on this, I guess it's numbered line 4 there, your sentence refers to the massive decline and extremely low abundance. Do you see that?
Yes.
And if we could go to paragraph 37. I'm sorry, that's page 18. And then you see lines 9 through 11, the sentence where you say that the ongoing decline represents a massive failure of trustee agencies. Do you see that?
I do.
And then if we could go to paragraph 75. That's on page 35. And if we look at line 8 there, you refer to a massive harmful algal bloom in San Francisco Bay.
I see that.
And then if we could go to paragraph 79 on page 37. And at line 16, you refer to the effects of massive fish kills.
I see that.
And then paragraph 81. I think I have the wrong paragraph here, but I think the point that I'm trying to make is, are you using that adjective massive as a scientific term in your testimony?
I'm using it to emphasize very large.
Okay,
Yes.
and does that adjective have a scientific definition or meaning to you? That adjective massive?
You know, it's interesting. Massive would refer to mass, so guess I'm running out of adjectives to describe very, very large impacts. It does have a meaning to me. I think it, in common usage, indicates a very, very large thing.
Okay, so you were using it more kind of in common usage to describe the scale
Yes.
of the particular subject.
I was not indicating that I had measured the mass of something.
Right. If we could go to Ms. Mullen, if we could scroll to page 88, paragraph 271. And this paragraph, Dr. Rosenfield refers to Baykeeper Exhibit 96, which is the State Board's August 3rd, 2010 flow criteria report, and which was submitted with your testimony, correct?
Correct.
And you cite to this report multiple times in your testimony to support certain statements you make regarding the importance of in-stream flows needed to maintain public trust resources, correct?
Correct.
Ms. Mullen, could you bring up, please, Baykeeper 96? And if you could maybe show the full screen. Yeah, thank you. the first page of this exhibit that you submitted with your testimony, that's the title page of the flow criteria report, correct?
Correct.
And if we could please go back to Baykeeper Exhibit 1. Again, at paragraph 271, page 88. And then there's a hyperlink to provide the source here. If you're able to click on that or open that, Ms. Mullen, it's at the bottom, yeah. And see whether that will open. And then if you could scroll down to the final report hyperlink. It's in the middle of the page. They're all alphabetical. And it says final _ RPT. Dr. Rosenfield, is it your understanding that this is the web page where the state board maintains a copy of the flow criteria report?
That's my understanding.
And if Ms. Mullen, if you could click on that link for the August 3rd report, final report, it's at the bottom. Dr. Rosenfield, do you see here that the first page of the report that's hyperlinked in your testimony and provided in PDF format actually is a page with a note heading or with the heading note to readers?
I see that.
And then if we go to the next page of the report, we just page down one. That's the title page, correct?
Correct.
Is there a reason why you did not include the actual first page of the report as it's maintained on the state board's website and linked in your testimony?
No, there was no intent, no reason. Just an error.
Okay, Ms. Mullen, could you please pull up the sites cross-exam exhibit I sent to the AHO yesterday? And I think the document file name starts with sites cross-x SWRCB. And for the record, I guess we should mark this next sites exhibit next in order.
Yes, I was just asking my team what number that would be.
Okay, and then Dr. Rosenfield, this exhibit includes the first 2 pages of the 2010 flow criteria report as it's maintained on the website, including the note to readers page. Do you see that? And maybe you can scroll down, Ms. Mullen, and just go to the next page as well.
And for the record, this will be sites, we'll mark this exhibit sites 303.
Thank you.
Mr. Hitchings, just for clarity, is it just the first 2 pages or is it the whole document?
Just the, well, this exhibit has 3 pages on it. And I'll get to that, but I just wanted to note that this is the first 2 pages as we just viewed on the website to show how it was maintained. And then if you could go back to the first page of this exhibit, which is the first page of the document as it's maintained on the website. I've highlighted a couple sentences at the beginning of the report on the note to readers page, and they state that this report required by Water Code Section 85086C Delta Reform Act in 2010 suggests the flows that would be needed in the Delta ecosystem if fishery protection was the sole purpose for which its waters were put to beneficial use. In keeping with the narrow focus of the legislation, this report only presents a technical assessment of flow and operational requirements to provide fishery protection under existing conditions. We know, however, that there are many other important beneficial uses that these waters support such as municipal and agricultural water supply and recreational uses. The State Board is required by law to establish flow and other objectives that ensure the reasonable protection of beneficial uses. In order for any flow objection to be reasonable, the State Board must consider and balance all competing uses of water in its decision-making. So you see that highlighted text,
I
Dr.
do.
Rosenfield? Do you disagree with anything in that text, in those highlighted sentences?
No, I don't.
And then for the third page of this exhibit, Hearing Officer Kinsey, I'll proffer that I've included on this page a copy of the State Board's webpage that we just viewed earlier, where the flow criteria report is maintained. And I've highlighted the same sentences that I did on the note to readers page. For the record, I think it was helpful just to have this, since we had kind of clicked through a couple electronic versions on the State Board site. So I'll make that proper.
Noted. Thank you.
Okay, thank you for walking through that. If we could go back to Baykeeper 1, Ms. Mullen, and go to page 6, paragraph 11. And then if we could scroll down to line 27. And then this continues on to page 7, lines 1 and 2. So maybe we can just start there. Sites proponents also claim, so that last sentence. And then maybe scroll down. So in the last two sentences of this paragraph 11, Dr. Rosenfield, you assert that there's no evidence that the site's proponents will mitigate for negative impacts that will occur due to site's operations. Is that a fair characterization?
Yes, I mean that site's operations as proposed will cause negative impacts. There are mitigations that are proposed that will not fully mitigate those impacts.
So you are aware that the authority is required to comply with the mitigation monitoring and reporting program that's part of its project approval under CEQA?
I'm not aware of the requirements under CEQA, but I'll take you at your word.
Familiar with and I'm going to just refer to it as the MMRP. Are you familiar with the MMRP that was part of the project approval?
I believe I reviewed it at some point, yes.
But you can't recall anything specific from that?
I recall specific mitigations that are described in one document or another that I found to be unlikely to fully mitigate the harms that they were intended to mitigate.
Are you aware that, oh, I'm sorry, I thought you were finished.
Yeah, that's what the statement means, that the mitigations that I am aware of will not mitigate fully for the harms caused by site's proposed operations, which is contrary to the claim that sites is only diverting water that is excess or surplus to environmental needs.
But do you disagree that the MMRP itself and sites' obligations to comply with that constitute evidence to support their assertion that they will be mitigating impacts?
They will be, no, I don't agree that many of the mitigations will, things that are called mitigations will actually mitigate impacts.
Are you aware that CDFW's October 24th, 2024 operations ITP for the project also requires compliance with that MMRP, at least as it relates to covered species in the biological resources section of the final EIR?
Can you repeat the question?
Yeah, are you aware that that operations ITP I just mentioned for the sites project requires compliance with that MMRP as it relates to covered species?
I'm aware that the ITP requires compliance with the terms of the ITP.
And are you aware that under that ITP, the Sites Authority is required to prepare and submit to CDFW a final mitigation report, which includes details on when each mitigation measure in the MMRP was implemented?
I have not fully read the ITP. I've perused it in general. So if they're required to submit a report, then they are. I haven't read that detail, but I assume that sounds pretty standard.
Okay. Dr. Rosenfield, your testimony includes some statements regarding the efficacy of fish screens at the proposed points of diversion at Tehama-Calusa Canal Authority and at GCID, correct?
Correct.
Have you viewed the fish screens in person at those proposed points of diversion?
I have not, nor would viewing them affect my opinion. I'm relying on published reports and literature.
So you've never visited the proposed points of diversion at those locations?
I have not personally visited those diversions, no.
And have you ever performed any testing of the approach and sweeping velocities associated with the operation of the fish screens at those proposed points of diversion?
I believe my testimony about the diversions and the screening efficacy with regard to green sturgeon, federally listed species. And I believe in my testimony, I indicated that the National Marine Fisheries Service has stated that there are no screening criteria that they've accepted for that species. That was the nature of my testimony about screening efficacy. So in answer to your question, I don't think anybody has done the kinds of experimentation that you're talking about.
Okay, my question was whether you have ever personally performed any testing of the approach and sweeping velocities.
No, I have not.
Okay, if we could go to Ms. Mullen, page 18, paragraph 37. And Dr. Rosenfield, at lines 7 through 9, you state that the spring and winter runs of Chinook salmon no longer support fisheries. Do you see that?
That's correct.
And are you aware that the commercial fishing industry on the Pacific Coast is allowed to take a percentage of endangered winter run Chinook when fishing for fall run Chinook during the fishing season?
Yes, I understand that they have permission for incidental take of those fish.
And then are you aware that when the ocean fishing fleet harvests endangered winter run, those fish are sold on the market with the fall run that are harvested?
I'm not aware of the disposition of what happens to the fish. But that's not what I mean by supporting a fishery. I mean, bycatch is not the fishery, it's bycatch.
Well, bycatch typically isn't sold, right?
I'm not testifying as to what happens in a hypothetical fishery.
Oh, okay. I thought you were kind of dismissing the significance of winter run as bycatch being sold. Are you aware that the Pacific Fishery Management Council reported that the ocean harvest impact to age 3 winter run in 2022 was estimated to be 26.2%?
I'm only aware that I heard you raise that issue with Dr. Herbold. I have not read that report.
And then are you aware that that 26.2 ocean harvest impact rate exceeded the 20% maximum impact rate allowed for ocean harvest of winter run in 2022?
Again,
Objection.
I've only heard that.
Go ahead.
I've only heard you say that to Dr. Herbold. I'm not aware of that statistic.
Have you or San Francisco Baykeeper ever opposed or objected to the Pacific Coast salmon fishery management plans allowing for the take of endangered winter run?
I'm not aware of Baykeeper having done that prior to my employment with Baykeeper, although it's possible, not since my employment at Baykeeper. No.
And you personally, or as part of serving as expert, you have not objected to that either?
I've not been asked to review those plans.
Are you aware that the estimated ocean harvest exploitation rate for fall run Chinook salmon in 2022 was 76%?
I'm not aware of that statistic, no.
And have you or SF Baykeeper ever objected to the ocean harvest exploitation rate that has occurred for fall run Chinook?
Again, I've not been asked to review those harvest management plans.
Okay, if we could go to page 40, paragraph 87, Ms. Mullen, thank you. And Dr. Rosenfield, is it a fair characterization of your testimony in this paragraph that you believe the 4% harvest limit for white sturgeon is too high?
The 4% harvest target is above what the best available science indicates is sustainable for the white sturgeon population. Subsequent to submitting this testimony, the California Fish and Game Commission changed the fishery for white sturgeon, first to no fishing. First, they closed the fishery, and then I believe they've reopened the fishery as catch and release only so that there is not harvest.
But at that time that you wrote this, is it fair to say that, in your opinion, that 4% limit was too high at that time?
Yes.
Ms. Mullen, if you can go to page 24 and section, the heading is, lowercase Roman numeral 4 there. Dr. Rosenfield, with the exception related to shallow water habitat, you don't reference in this section of your testimony the results of project-specific biological modeling done in the final EIR. Is that correct?
I'm sorry. Can you orient me to?
Well, through this section, the best I could tell is the only biological modeling that you referred to had to do with shallow water habitat, but that was the exception with regard to referring to or relying on any biological modeling done for the project in the EIR. Is that
Objection
correct?
paid.
Yeah, I'm not understanding your question.
I'm not
Did
sure
you-
what we mean by this section either.
Yeah.
Well, it's a section of the testimony, so we can scroll down in this section 4. So it's basically under the headings B1A, Roman numeral 4.
All the way through paragraph 68.
If that's where the section ends, yes.
Well, I mean, that you asked what the citations in this section. I think that's vague, so I want to be clear as to what you're asking about.
I'm actually going to move on from here. If we could go to page 29 and paragraph 60. And lines 22 to 23. Dr. Rosenfield, here you state that old and middle river flows are projected to become more negative under sites operations in most or all water year types for every month, October to March, May, and July to September. Do you see that?
I do.
You don't reference any of the sites project old and middle river modeling outputs for this statement, correct?
I did not put a citation here. That's correct.
Are you aware that the biological modeling done for the sites project examined South Delta entrainment and accounted for factors such as old and middle river flows?
I'm sorry, I'm not understanding your question.
Are you aware that biological modeling was done for the sites project that examined South Delta entrainment and accounted for factors such as old and middle river flows?
Objection
don't-
compound.
No.
Vague.
Sounds like we don't understand your question, Mr. Hitching, so I can sustain it, or if you can please rephrase it.
Well, are you aware that biological modeling was done for the sites project that examined South Delta entrainment?
Yes,
And are you aware that that biological modeling accounted for factors such as old and middle river flows as well?
when you say, can you say what you mean by accounted?
Considered.
Yes,
And then did you review those modeling results in preparing your testimony?
I'm sure that I did.
But you don't have a specific recall of them or what the results were?
No, because when old and middle river flow, as old and middle river flows become increasingly negative, entrainment of native fishes, many native fishes, increases, and in some cases increases parabolically. So I'm looking at the modeling of flows, and I think this gets to your last question too, although I'm still not quite sure. I'm looking at the modeling of flows produced in sites EIR, and interpreting them based on my expertise. Increasingly negative old and middle river flows will lead to increasing entrainment of various native fish species. That's just a matter of evidence that I've cited in my testimony. The modeling that's done for that by sites authority is not my, I mean, I've reviewed it, but I don't necessarily take it at face value.
Okay.
In particular, with regard to the impact and the effect of the impacts that are documented.
Okay, Ms. Mullen, could we go to page 30, paragraph 63? And the lines we could focus on lines 17 to 18. You state here that it's not possible to evaluate the merits of the site's proponents' proposed exchanges. Do you see that?
That's correct. Because they
And
are currently being evaluated and discussed according to the operations plan that I had at the time that I developed this testimony.
So when you made that statement, did you consider the biological modeling results for the project that included exchanges?
I did not pay much attention to the modeling that included exchanges because I don't think that they are reasonably certain to occur. And if they do occur, as I referenced in my testimony, the forthcoming biological opinions, which have now been released in draft form, call for improvements in temperature management in Shasta, regardless of sites' reservoir exchanges. So if sites' reservoir exchanges result in the temperature benefits that that sites' proponents claim, that's a water supply benefit, not a benefit to fish and wildlife, since those temperature benefits are going to be required of the Bureau of Reclamation anyway.
Do you know if there's exact synchronicity between how the exchanges or the carryover storage levels in Shasta relate to the modeled exchanges that have been done for the sites project?
There again, in your question is my objection to taking the analysis at face value. The modeled exchanges are not required of the Bureau of Reclamation, to my understanding. I mean, they certainly weren't at this time. There was no agreement. So what's modeled in terms of a hypothetical exchange is not as interesting as what's the real world effect going to be. And as I stated in my testimony, the real world effect is going to happen according to the biological opinions that I had, or the drafts that I had reviewed at the time. The biological effect that CITES claims is going to happen as a result of these exchanges was going to happen anyway.
But some of those exchanges that have been modeled and that are anticipated, those would be above and beyond the carryover storage and cold water pool management benefits that might be required under the buyouts. Isn't that correct?
No, it's not.
You don't think that any of the
once temperature, I can explain. Once temperatures are cold enough to support winter run Chinook salmon egg incubation, they are cold enough. Making the water colder doesn't necessarily help, as long as temperatures are cold enough to support, provide excellent support for incubation. Exchanging water the Bureau is going to be required to maintain adequate cold water storage in far more years than it had previously been required, whether or not there are exchanges. And from my understanding, CITES Reservoir Authority and its agreements with the Bureau of Reclamation can't really control CITES operation, can't really control Shasta operations anyway. The Bureau of Reclamation controls Shasta operations, and it will do what it needs to do, and it's what it's required to do under the biological opinions. So I just don't think the exchanges are reasonably certain to occur, and if they did occur, they are a water supply benefit in that they provide flexibility for the Bureau, but the Bureau would be required to provide the temperature benefit one way or another, according to the biological opinion.
But the exchanges under that could occur between CITES and the Bureau, those exchanges could be in additional year types than are otherwise currently proposed under the new draft buyouts, correct?
Objection, vague, speculation. I don't think we know anything about those exchanges. Like at what percentage, at what times, in what year types?
Okay, I'll move on, actually. And if we could go to Ms. Mullen, page 8, paragraph 16 of this testimony.
Mr. Hitchings, when would be a good time for a lunch break?
I'm just about through here, so.
Okay, great. Go ahead.
Great, thank you. And if we could go to line 28. I'm sorry, paragraph 16, line 25. And then continues on to the next page, lines 1 through 3. And in the last sentence of this, you state that you present conditions in your testimony under which you believe water could be diverted to sites without further impacting native fish, wildlife, water quality. Do you see that?
I see that.
And then can you point to where in your testimony you present those conditions?
I'm using the word conditions in a different sense than you may be thinking of it. I'm not presenting conditions as in terms and conditions. I'm presenting conditions as in ecological conditions under which CITES diversions would not exacerbate harms, or may not exacerbate harms, I should say. So what's described below are ecological conditions, such as I described in my opening statement that you objected to, showing that I'm providing, based on the best available science, flow levels and thresholds that should be deemed to be protective of fish and wildlife species. Those are ecological, environmental conditions that the NGO coalition and others have turned into proposed conditions in the legal sense on site operations.
Okay,
So-
thanks for clarifying that. That's all I have. Thank you.
All right, thank you, Mr. Hitchings. I think at this point it would be, we will take our lunch break. When we return, I will look to see if there are additional cross-examinate. Well, I guess I can look now whether there are additional cross-examination questions. Do I have Mr. Soderlund? Do you anticipate having questions for Dr. Rosenfield?
Yeah, I'll probably have a few, like just when I mean a few, it will be a few minutes.
Okay, thank you. And then is it Ms. Mitchell, I believe? Do you have questions?
We do not have questions. Thank you.
Okay. Thank you. And then Ms. Mendel-Rice, do you have questions?
We are reviewing our list to cross-check what sites has already asked. We might have a few, but since Dr. Rosenfeld already has to come back for Mr. Soderlund's questions, I hope that that is okay.
Yes, that is fine. And we were going to break anyway in terms of redirect and that kind of thing. So with that, is there anything else we should address before lunch? And otherwise we will, yes, there's a hand. Ms. Chester.
I apologize. This is a little off topic, but I understand from this morning that Mr. Ratto will not be available until the 7th. And my understanding is that any supplemental evidentiary objections will be due on Wednesday, the 6th. Just to confirm, we have not decided necessarily the scope of any objections because we have not heard the direct or cross-examination from Mr. Ratto. Do we have an extension for submission of any evidentiary objections after he is available to testify?
We will certainly account for that once and we can figure that out once we find out when Mr. Ratto is available. Mr. Reese, I see you're on camera. Do you have any update at this time, or would it be better to report back after lunch?
I do have an update, and it's still Thursday.
Okay, thank you. My inclination is going to be, given the pace at which we are proceeding, my inclination will be to take, I'm not going to make a final decision. You can think about it at lunch, but take tomorrow afternoon off calendar, and then we could reconvene on Thursday and get that done and basically conclude our case in chief with the understanding that we have outstanding evidentiary objections to deal with. That's what I'm thinking, but I will be open. Would anyone like to comment? And then Ms. Chester, to your point, there would be I guess we would make an extension probably until November 8th for the remaining evidentiary objections from the authority.
Thank you.
Yeah, assuming we go that way. Are there any other comments on procedure before we break for lunch? We can also discuss once we get back. All right, let's go ahead and make it a nice round number. I will see you back here at 1:15 and we'll pick up. Thank you very much.